My lord, on 9th, one original litigation is fixed. I have filed an IF for intervening in this case. So it may also come on 9th.
Yeah. I beg your lordship over an IA, your lordship, which was filed in 2023. This, the matter your lordship is aware of pertaining to disciplinary proceeding of subordinate judiciary. The matter can be fixed, your lordship, as per your lordship's convenience, on a date before 15th, your lordship. If the matter can be fixed, the matter is yet to be taken up, your lordship. The matter was filed in
Next week, Shiloh.
I'm grateful, your lordship. I'm grateful.
May I pray before Lordship? I read before Lordship regarding item number 46. This in earlier food occasion matter was my lord left over food occasion, my lord. My lord, earlier food occasion, this matter is left over. My lord, in this case, we prayed for stay regarding our Patta land, which is Patta land, which was evicted by the state representatives without following the procedure of fair compensation 2013, my lord. It may be taken at 2 p.m., my lord,
No, 2
for
p.m.
urgency, my lord.
We'll try and take up.
Master blessed.
Thank you, Mr. Lordship. Lordship, I beg to mention item number 5 and item number 8, Lordship. Lordship, RS Mr. Council is out of station, Lordship.
You have informed the other side.
Yes, sir. I have submitted the adjournment.
MS,
M. Nirola.
MN,
M. Nirola.
M, Maharashtra,
Yes, Lordship. Manisha.
okay, M, Nirula. Learned Council, praying for MS, Mr. RS Mishra, Learned Council for the petition, have to wait for listing of the case. When?
Can it be on Friday,
Friday? No,
Monday,
16?
Monday. Huh?
Monday.
16. 16?
16 Monday?
Friday next.
Can it be on Monday, Lordship? Next-
No.
Lordship, in item number
16, 16.
it
It
item-
is submitted that consent has been taken from the Land Council for the respondents to make a fair item 5 as well as 8.
8 year,
Same.
yes, Lordship. So item number 5, there is the interim order, Lordship.
Interim order passed.
Obliged, Lordship.
My lord, this matter relates to my lord encroachment of the private land of the petitioner by Forest Department. Encroachment of the land of the petitioner, private land by the Forest Department, my lord.
Motion.
No, my lord, admission.
Give it to the court master next week.
12th, my lord.
Next week. Don't fix the date yourself.
Yes, my lord.
Yes, please, Your Lordship. Lord, I beg to mention for listing of a matter, Lord. This matter,
matter.
Lord,
Subject matter.
subject matter is the construction of PMAYG house, Lord. The entire money has been misappropriated by the respondents, Lord, but no construction has taken place, Lord. On earlier 2 occasions, Lord, the matter came to be listed, but due to paucity of time, the matter could not be taken.
Next week.
I am obliged to.
My lord, I beg item number, my lord, 38, my lord. 38, this matter may be listed, my lord, on next Wednesday, along with, my lord, 2 other matters, my lord.
Next Wednesday holiday.
My lord, then, my lord, on Friday, my lord,
16
on 16th.
or 19.
Along with, my lord, the WBC number 7271 2023.
Oh, you don't know about that. We can fix this one.
My lord, a similar matter, my lord.
19, item number 38.
38, my lord. My lord, I am giving my number, my lord.
No, we can fix this 31. We don't know about other 2.
My lord, similar matter, that's why I am mentioning, my lord.
On the prayer of Mr. A. Manna, Planet Council for the petitioners, raised by case on 19. You submit separate mention memo.
May I give my lord a number, my lord, to the
Next.
Your Lordship, I beg to mention listing of a writ petition on Friday as it was last listed on 10/11/2023 and till not be listed.
What is the
Subject matter is
subject
about
matter?
no confidence motion against the president. No confidence.
Panchayat is taken over, madam. Now government is ruling, yes. Panchayat bodies are no longer in existence now. File your petition, it will come up. Is it not, Mr. Nath? Mr. Nath?
Yes.
They are no longer in existence. Government has taken over.
Wherever the term is now, after the term is complete, it will be
It will come on its own term.
Lordship, matter relates to mutation and partition of land. Kindly allow this matter-
Mutation, partition of land.
Yes,
Yes,
uh,
motion,
motion.
file, it will come accordingly.
Lordship, kindly allow this matter 9th of February
File, it will come accordingly.
of that.
I beg to mention again item number 48 of today's list. This matter is relating to the surrogacy, Lordship, that item number 48.
Why it has come for orders?
That is not available.
Check it.
Only my
If possible, I will take up, otherwise we'll fix a date so that we can take it up on a date. Yes.
May I please, Your Lordship. Your Lordship, I beg to mention one read petition, Your Lordship, for listing, Your Lordship, regarding settlement of ferrygat, Your Lordship.
Bench four matter perhaps. Bench four.
Hi, Your Lordship.
I beg to mention one great petition to be listed on 15th June.
Bit louder, madam.
Lordship, I beg to mention writ petition to be listed on 15th June for orders.
What is the subject matter?
Lordship, I don't know about.
Don't know. Then come back tomorrow.
For motion item number 1,
Well, I have received an instruction in the matter. In fact, nothing, the notice was issued by the Deputy Commissioner pursuant to the Honorable Court order.
Yes, it appears so.
Yes, yes.
At page
Uh,
44.
Yes, my lord. And in fact, by that order, the inquiry was directed to the Deputy Commissioner, and the Lanka Municipal Board will accordingly decide their claim. Entitlement. The second last paragraph.
Those petitioners.
Those petitioners along with others. So they are not at this stage not to be apprehended. my lord.
It is
Ultimately,
basically a fact-finding inquiry
It's
for
a-
the for these petitioners.
for this petitioner, not for this petitioner, the petitioner of that writ petition.
No,
and
their
along with-
their
along
case will
with
be
their-
examined for allotment.
Yes, yes, yes.
But here there is some observation subject to hearing of all the other allottees.
All others.
So they are other allottees. These
There are
petitioners.
there are other allottees. Well, in fact,
So as on date,
Not-
it is a
fact fine.
fact-finding inquiry for them.
Correct.
And you, because of this order, you are ensuring their participation.
Their participation. That is
Now,
what is what.
in the event anything is contemplated,
My lord.
then if you want to contemplate any action,
Mm.
then so cause notice
They will be given.
will be.
They will be given.
I
In
think
fact,
that will,
Lordship.
considering pendency of this writ petition on 26/12/23, they have held a meeting that because of pendency, they are not going.
right,
They are
that is why
Correct.
it should be closed at the very
Ye-
beginning,
yes, yes,
otherwise
yes,
notice
yes.
will be issued, then everything will be.
my lord, they have postponed their meeting. So
We can observe,
Lordship may allow them to go ahead with that. They will be given notice at the. due
if
time.
after fact-finding inquiry,
Yes.
the municipal board decides to say contemplates to take any action,
Lordship.
then proper so cause notices will be served to the
Notice will be
petitioner. So at this stage, there is no apprehension on the part of the
No
petitioner
apprehension, no.
for cancellation of their appointment.
Correct.
I think that will
Yes,
be,
yes. That will settle.
otherwise everything will be stalled.
Everything will be solved. In fact, they have they adopted a resolution on 26/12 that because of this, they are not proceeding.
So envisaging that, I asked you to
True,
obtain
correct.
instruction.
Lordship.
Third, Mr.
M.H. Soikia, Lordship.
M.H. Soikia,
Lordship.
learned counsel for the petitions. Mr. Nath, you will appear for?
Lordship may record my name for the respondent.
Mr. Dinath.
Including 4 more.
Mr. Dinath, learned senior government advocate, Assam, for all the respondents.
Lordship.
The petitioners hearing, comma, 21 in number, comma, have joined together to prefer this writ petition, stating that they have a common cause of action. As it is stated by the petitioners that sense the unnecessary details, it is noticed that the petitioners have stated that they were earlier running their petty businesses from shops, rooms, stroke pitas allotted to them by the Lanka Municipal Board, within bracket earlier Lanka Municipal Committee. On 6/9/2014, Lanka Municipal Board issued a notice inviting applications from all existing businessmen, traders for allotment of room in the newly in the business center stroke market complex. A business center campus. For allotment of shops, rooms, pitas in the newly constructed business center campus. Some of the petitioners hearing at that point of time, approached this court by filing a writ petition, WBC number 1122/2022. And the said writ petition was disposed of by an order dated 28/2/2022 with a direction to the Deputy Commissioner Pujai Sankardev Nagar to make an inquiry on the claims of the petitioners therein regarding allotment of rooms, space, and pitas in stroke in the newly constructed multi-story business center stroke market complex of the Lanka Municipal Board, subject to hearing the other allotees who were allotted room space, vitas, dairy. Also, in reference to the said directions, the Lanka Municipal Board authorities allotted shops, rooms, vitas to each of the petitioners hearing on payment of fees, etc. Fees and other charges. Finding that the petitioners hearing were running their businesses from the same place. Full stop. The petitioners have projected that they have taken possession of their allotted rooms in the multi-story business center stroke market complex. And have been running their businesses. They are from till date. Full stop. Para. The petitioners have stated that on 6/11/2023, comma A, notice has been issued by the executive officer, Lanka Municipal Board, asking them to attend a hearing on 10/11/2023, along with all related documents at the office of the District Commissioner, Hojai, Sankodev Nagar. Post of the notice as mentioned that the hearing is fixed as per the order of this court regarding allotment of room space in the newly constructed multi-story business center stroke market complex of Lanka Municipal Board. Apprehending cancellation of their appointment allotments in the multi-storied business complex stroke market complex. The petitioners have approached this court first up on Mr. Nath. On the previous date of listing of the writ petition, Mr. Nath sought some time to obtain instruction. Obtaining instructions as regards the region behind issuance of the notice dated 6/11/2023. Post up. Mr. Nath has submitted on receipt of instructions, to the effect that the petitioners have been called for the hearing in terms of a direction made in an order dated 28/2/2022, passed in a writ petition, WPC number 1122/2022. Full stop.
He is petitioner number 6. The first petitioner is petitioner number 6 in that case.
Monihar Sinha,
Yes, yes.
he is here again.
He is here again.
Why?
Lordship, I have no knowledge regarding this. No, Monihar Sinha is there. Name is there.
I have seen page 43.
Yes.
If he has been allotted already shops,
He said
then why he had preferred this 1122?
he apprehended that he apprehends that he may be cancelled. That is why he has approached now.
Oh, but in 1122,
That was a
what was the apprehension?
that was not for rape.
No, they have said that They were not allotted
In-
shops.
In the meantime,
Contradictory.
in the meantime, they said that they have been allowed to operate some space, from some space. L- l- Let it be as it is, my lord. Whatever is there, my lord, lordship may not observe to that. Only if any action is taken, they will be.
The a copy of the said order is annexed to this petition as annexer 6. Full stop. From the from the order dated 28 to 2022. It is noticed that the petitioners therein had projected that they had applied for rooms stroke so and so in the market complex of so and so. And the respondent municipal board did not consider their cases. Also. Finding the case of those petitioners covered by other orders passed by coordinate benches of this court, the said petition WBC number 1122/2022 was disposed of with a direction to the Deputy Commissioner within bracket presently, District Commissioner Hojai Shankar Devnagar to make an inquiry on the claims of those petitioners regarding allotment of rooms stroke space in the multi-story business center stock market complex of the Lanka Municipal Board, Pakihin Italics on the page 45. Subject to hearing of the other allottees of the said market complex, who were allotted spaces stroke rooms in the market complex prior to filing of the writ petition WPC number 1122/2020. Para. Mr. Das not referring to the said direction passed in the order dated 28 to 2022 has submitted that the petitioners herein were issued the notice dated 6/11/2022 in compliance with the said direction made in the order dated 28 to 2022. Full stop. As other allottees were also afforded, as a direction was made to give a hearing to the other allottees in the multi-story business center stock market complex. He has submitted that instructions have been received to the effect that for the purpose of in respect of the petitioners in this writ petition, who have already been allotted rooms, spaces, and so in the market complex so and so. The notice has been given only for the purpose of a fact-finding inquiry. Full stop. And not for cancellation of these petitioners, the present petitioners' allotment of rooms with us so and so in the market complex so and so. Full stop. He has further submitted that if after conclusion of the fact-finding inquiry, the Lanka Municipal Board takes any decision to cancel all or some of the allotments. All or some.
They are running their business from that space, but no formal allotment has been given to them at this stage. Because the allotment process is because of the order of the Honorable Court, it is still not finalized. They said that they weekly, in the weekly market, in a day or on Tuesday, they are doing their business. in
But
the
page
open
72,
space.
page 72 say, for example,
Logic.
just for example,
Yes, sir.
see transaction note. Biswajit Dutta allotted Pita, ground floor, Lanka Business Center. This is your document. All
they
these.
They have taken a decision that for ground floor, this much amount has to be deposited, and for first floor, this much amount has to be
But
deposited.
allotted means it is past.
They have
Used to be allotted is one thing, but here allotted.
the final decision they have not yet taken. Logic. Otherwise, they are in position of they are doing business there, and final decision is still pending. Because
If you dispute this, then
logic,
because say 71,
yes,
Lanka Business Center Kuthali বন্দোবস্তি পোৱা বাবদ পৌৰসভাৰ উন্নয়ন কল্পে অনুদান
but
Kuthali বন্দোবস্তি পোৱা
logic.
this language speaks contrary to your submission.
Language speaks logic.
Hmm? Because all this they have
They will all allotted logic.
allotted all these documents shows
Logic.
allotment
Logic.
and deposit of money.
Money.
Some right has been accrued to them.
Logic.
Because it is sum of rupees 1 lakhs,
Yes.
not a sum of 100 rupees or 200 rupees.
It was pursuant to a decision of the board only, well,
Hmm.
logic. Logic by object. Earlier they were allotted.
If any hospital takes any decision for cancellation of allotment, stroke provisional allotment
Logic.
of SOPs, Pitas and so and so in the multi-state business complex, stock market complex, which are likely to be prejudicial to any of the petitioners hearing, proper show cause notice would be issued and the notices would be given all reasonable opportunities to represent their cases. In view of such submission made by Mr. Nath, appearing for a respondents, including the respondent, long-term municipal board authority, the apprehension raised by the petitioner's hearing appears to be premature at this stage. As in the event of initiation of any process for allotment, cancellation of the allotments, provisional allotments, a further process would be initiated with so-called notices.
Yes.
In such view of the matter, the writ petition, and this court is of a considered view that the writ petition is not required to be proceeded further, and accordingly the same is closed.
Deeply obliged.
My lord, in this case, my lord, petitioner filed, my lord, the additional affidavit, my lord, the complaint petition, my lord, when on record, my lord.
Now tell me, Mr. Dingia,
Lordship.
any of your judgments,
My lord,
any of your judgments,
yes,
which you have relied upon,
One,
says about quashing of proceeding
yes, ma'am.
in a court of law.
Not-
Quashing of investigation is different. Tell me, any of your decisions you have relied.
Well, one judgment, my lord, passed by the Honorable Court, my lord, 2014 2 GLR, my lord. Here, my lord, the Shashikant Prasad, in paragraph 7, my lord. Paragraph 7, my lord, it is stated, my lord, that there is no dispute to the proposition. Lord,
Shashikant
Shashikant Prasad, my lord,
Prasad. Okay.
and versus Muhammad Kadir, my lord. My lord, this is my lord, Ujjwal Bhuya, my lord.
Paragraph 7.
7, my lord.
GLT, GLR.
GLR, my lord.
Okay, paragraph 7. Then the complainant.
There is no dispute to the proposition.
No,
that
which paragraph?
Paragraph 7, my lord.
I am also holding Shashikant Prasad versus another and another versus Mohammed Qadir.
Yes, sir.
Now, paragraph 7 starts with the word that the complainant after believing. Mr.
Is it, my lord, the GLR online, my lord?
Because this court has held already. There is distinction between two. This court's the order itself. And plus Supreme Court decisions. So that is why I'm asking. There is difficulty.
My lord,
Just because forum convenience will not see, say, Article 227 also.
Not.
A High Court. Article 227. Cause of action is one thing.
Lord.
You might have a very good case for quashing the complaint. But question is, which High Court? See, for example, 227. 226 says about cause of action, right?
Lordship.
227 says every High Court shall have superintendence over all courts and tribunals throughout the territories in relation to which it exercises jurisdiction. Right?
Right.
So we have only power of superintendence over all courts and tribunals under 227. We do not have any power of superintendence over a court of metropolitan magistrate holding its court at Calcutta. Otherwise, 227, it is the Calcutta High Court. Now we come to 226(2). It says about cause of action.
Yes.
Now, cause of action, all these agreements, vehicles were executed here. You purchase the vehicle here, paying the installment here. But suppressing all this, suppose a complaint has been filed. Those are cause of actions. Executing the agreement at Sibsagar, purchasing the vehicle at Sibsagar or Guwahati, paying the installment at Sibsagar, receipt of the installment by the company financier at Sibsagar. Those are cause of action. But a part of cause of action might arise in Calcutta, we don't know. But making some statements and averments. The financier has filed a complaint in Calcutta.
But in complaint case, my lord, there is no any, my lord.
Calcutta court, please. And the magistrate has taken cognizance and issued summons for your appearance. Now it is all this cause of action was considered by a court and issued summons. That is a difficulty. If you go through all the decisions again, Supreme Court, Kusum Ingot, you'll find. You will rely upon Kusum Ingot also or not?
No.
Kusum Ingot. Then subsequent decisions. Cause of action is one thing, but an order of a judicial court to interfere with a order of a judicial court under superintendence of another high court is another thing. And this court has also held in another case that judicial order is not to be interfered with because it is a proper forum which has to be approached. We'll take up both these cases. What is the other case?
My lord,
On the motion stage itself. We'll have on 17th Saturday.
Lordship, my lord, Lordship may issue notice, my lord, in the meantime, my lord. My lord, the other case also, my lord, this honorable
Both
court.
will be taken up together on 17th.
There is, my lord, already, my lord, passed this honorable court, my lord. That is
That I have stayed just for your arrest.
Lord.
I have not stayed the proceeding.
Lordship, Lord.
Mr. Dihingia,
Lord.
I did not stay the proceeding. Did I stay the proceeding?
No. On 17, my lord.
17 both.
Lordship.
Hired Mr. Ellen Dihingia and Council for the petitioners and
1, 2, and 3.
Mr. S.S. Roy,
Lordship.
Junior Government Advocate,
Lordship.
some for the respond number 1, 2, and 3. Full stop. The Mr. Dihingia, the Council for the petition has submitted that the complaint, petition of complaint case number CS stroke A0932 stroke 2023 has been brought on record by way of an additional affidavit. First stop. List this case along with WBC number
7544, my lord. Item
Listed
number
today?
49. Yes, Lord. Item number 49, Lord. 23, Lord.
7544 2023 on 17/2/2023. 49 লিখিব Ellen Dihingia 49 দিও Hart Mr. Ellen Dihingia learned Council for the petitioners and Mr. S.S. Roy learned Junior Government Advocate Assam for the respondent number 1, 2, and 3. List this writ petition along with the item 2 on 17/2/2023. The interim order passed earlier shall continue till the next.
Must oblige.
Bring out something, judgment, where this court can stay proceedings of Delhi, Mumbai, Hyderabad.
Item number 3.
Lordship, the matter may be passed over for time being, Your Lordship. My senior is on legs, Your Lordship.
Okay.
Item 4.
Any instruction?
Not received, Lordship.
Hmm?
Not received. I prefer some more time. Lordship,
I have the verbal instruction, my lord. On last occasion, the lordship is to obtain instruction who is the competent authority. That is, lordship, additional district commissioner Kasar, my lord.
Additional District Commissioner Kasar.
Additional district commissioner Kasar Silsor.
the second.
And my lord, the 3G award already approved by the NHI Judicial Authority, lordship. That is amounting to rupees, my lord,
Oh.
536, 16 lakhs, 51, 128.
PG award already passed.
It is not communicated to us, Lordship. We are not aware about any notice.
We have approved the amount, lordship, that passed by
So
the
that-
Kala, my lord.
Right. So whether I asked whether 3D2, 3D subsection 2 stage is over or not. It appears to be over.
No, Lordship, in term of that section, they are.
You have still recourse, Mr.
Lordship, Lordship.
I tried to preempt the issue if 3D2 stage is over or not. But 3D2 stage is over. Now your recourse will be under 3D5. Then we'll issue notice if the 3D1 is over. We can't help it now. We thought that we'll try to ameliorate your apprehension at the motion stage, but now it is not possible.
Lordship, that 3G5 says that required shall be paid amount determined by the order of the competent authority and right users, right? That is in term.
3D5, that is arbitrator, and arbitrator can still exercise power under 3G7, market value.
Yes, ma'am.
He can direct. But now if once 3G1 is over, I don't think Kala can do anything. Hired Mr. F.J. Majumdar, Learned Counsel for the petition, R.K. Talukdar, Learned Standing Counsel, NHI DCL 145, and Mr. S.S. Roy, Learned Junior Government, Bugar Assam, for Response number 2, 3, and 6. Agor Para 2 to Likiti. Agor Para 2 to Mr. Talukdar, Learned Standing Counsel, NHI DCL, was asked to obtain instruction as regards the present stage of the acquisition process. Kama has submitted that the NHIDCL has already approved the 3G amount proposed and assessed by the competent authority land acquisition. Issue notice returnable on Swens.
Lordship, one more submission that the 3G3 says that before proceeding to determine the amount under subsection 1 or 2, they shall give a public notice.
We'll examine that.
And this
Now we have to examine.
this public
I
notice-
thought that 3G3 was over or not. If not over, then you'd have been allowed to represent your case before the competent authority, so that your case regarding industrial or market, industrial aid can be considered by Kala. But law is that once he has passed the award, it becomes functus officio. We'll have to examine that whether 3G3 is complied with or not now. I tried to shorten your case,
I understand, Lordship.
but it could not be now. Issue notice returnable.
11-3.
As Talukdar for 1, 4, and 5, Roy for 2, 3, and 6. No formal notice. Extra copies. Within 2 working days. Item number 6. Yes, any up to date status? Other issue notice.
Actually, as per verbal instruction, the scheme was no longer exists.
To my understanding, that it has come from
Lordship.
some document.
Exactly, Lordship, Lordship. And I am unable to collect any document.
But I know in some other cases, documents are placed
Lordship.
and order is framed by the central government.
If there is such
Under Section 3 of the Essential Commodities Act.
Lordship.
And plus, many of the repetitions were filed by cooperative societies that since this scheme is gone.
Gone.
But our areas are pending. Please give a direction to release our areas. In all these repetitions, I have found that those GPSS societies have come before this court saying that this scheme has been already
Closed.
no longer in existence, but our areas are pending. That is why I asked you, will you notice?
No, Lordship, notice.
It will,
they do not serve any
it will
purpose.
remain infructuous from day one.
No, then in infructuous matter, notice may not be issued, Lordship. I
That
may
is
be
why I
allowed to.
requested both the council to obtain fresh instruction whether this thing is alive or not.
Not-
If law is passed already,
That
that
is-
this scheme is not in
Lordship,
existence.
Give one more opportunity that I will try to find out the notice.
But my verbal instruction, it was no.
The
law.
verbal, I understood, Lordship. He's right on his submission, but I need the notice, so I
Hi,
may
Mr.
engage
Mazumdar.
council, Lordship.
You have come with a prayer, but to my limited understanding, this petition will be infructuous from day one.
That
It
is.
will not serve any purpose to pass an order after 2 years.
That is why I am praying. that
Abject
one more-
Mazumdar Land Council by a petition has sought for listing of the case after a week. List the case accordingly after a week on a date to be fixed by the office in the motion below.
Lordship.
Mr. S.S. Roy, Learned
State Council.
State Council shall obtain instruction as to whether in the system of public distribution system, revamped public distribution system, the system of intermediaries, like the petition society herein, are still in existence.
Item number 7.
Possibly is that matter within a period of
Section 9.
lordship.
Lordship, kindly pass over the matter for them.
Mr. Saraf, then we can do one thing. We can issue notice returnable on 17. Stay of the order. We'll pass the order.
Lordship.
Otherwise, sometimes at the motion says, if I pass an order, no opportunity. Heard Miss D. Saraf, Learned Council for the petitioner. Mr. S.S. Roy,
Union of India, CGC.
what do you say about this order?
Lordship. GST will.
Page 31, no GST. It is interpretation of section 9 of the General Clauses Act. You are not required to understand GST,
Lordship.
Section 9.
though it is the order is passed by a GST authority. Please read 7.0.
Lordship.
Right?
Lordship.
7.0.
Lordship.
If Mr. Roy is given, said that you have to deposit 100 rupees within 30 days from appointed day.
Right.
So appointed day is first of the month. So how do you count 30 days? General Clause. These are Mr. S.S. Roy, Central Government Council for Response number 1 and MS A.M. Deca. M. Deca, Learned Council, representing Mr. S.C. Kyle, Learned Standing. Or he's available or not? Kyle is available in the court.
What?
Let him come in his work. I think it will be better to pass an order of state
Lordship.
in his presence.
Oblige lordship.
Item number 9.
You have been pierced out.
Yes. At the time, all the license permits of all the buses have been cancelled without following the due process of law.
Is there any
Within a-
procedure for cancellation of
Yeah.
permit?
Yes. After all, Lordship will appreciate this is a very vested right by grant of a permit, allowing these permits are issued for the buses to fly on the specified routes only. They cannot go this way, that way. Permit is specific, road specific, and they can fly there only. And license is issued only for that. And all other consequences follows in as much as the
fitness, the insurance, the everything will be applicable in that route only. If he goes to some other route, commits an accident there, insurance will not cover it. This is the situation. And for every cancellation, notice is a must. Can you see? The MB Act, Section 71. And if they want to introduce some new scheme, then also there is a procedure. How? They cannot just impose it. Specific. Road specific.
Now, your vehicle falls in the category, which
Of stage
category?
careers. Stage careers.
Yeah, some motor vehicle rules.
So motor vehicles rules. Here also, my lord, the rule 79. How they can do it? They want to put in some electric vehicles. That is, we are not opposing to it.
We are not into that aspect. We are into your
Yes.
stoppage.
Yes.
What is the procedure for cancellation of permit, say?
Cancellation of permit, lordship will find.
It would amount to,
Yes. It is amount to cancellation of permit. Section. Cancellation and suspension of permit, lordship will find it at page, if this is the book Motor Vehicles Act. Well, at here, page 101.
section, any idea?
86.
86.
Yes. The transport authority which granted a permit may cancel the permit or may suspend it for such period of things on the breach of any condition specified. Is not applicable if the holder of a permit uses or causes allows a vehicle to be used in a.
Yes, madam, 86.
Lordship.
So, your action amounts to
Cancellation.
cancellation of permit because 66,
Lordship.
section 66.
My lord, before that, lordship may I submit one thing. Without going to the merit, lordship may dismiss the writ petition at the limine, my lord, because of two grounds. Lack of authorization. Who is the petitioner before your lordship? First of all, who is the petitioner? Because as per our record, he is not the secretary of the union. In the RK meeting that is so and so, that is annexed in the writ petition also, his name is not there. In the PIL which is pending before this division bench of this honorable court regarding the traffic congestion, my lord, the RTA, the union is different union. They have implemented, they have filed implement petition in the month of December. The secretary president is different person. Now, who is the petitioner in this writ petition, my lord? And lack of authorization, there are so many judgment, lordship. I have relied on Rajasthan High Court's judgment is the author is the Honorable Justice Sandeep Mehta, division bench judgment. Lordship may kindly dismiss. And the second reason, non-joinder of necessary party. This is the decision of RTA, my lord. And RTA is headed by the district commissioner, not the transport department. Lordship, I'm relying the judgment. Who is the person before your lordship? He have to.
RTA is there.
Principal authority is
Lordship, but
there.
the RK is headed by the chairman. Chairman is the district commissioner. His
Who is
lordship,
the member secretary?
member secretary is a transport person, but the other department officers also there.
I don't know.
Chairman is the district.
Regional, 1 minute, 1 minute, someone.
Yes.
Regional Transport Authority.
Lord.
What is the provision for regional?
Provision, lordship may kindly have a look. Six. Lordship may kindly have a look the Motor Vehicle Act 1988, section 68 for a moment.
We come to that, but where is the Regional Transport Authority?
There's the authority. They have
I
been
think it will be
constituted.
there,
Yes.
defined perhaps.
Yes, my lord.
Well, let us go to that aspect.
Before the lordship may kindly have a look my written instruction that I have received from the.
We'll go one by one. We have patience. MS Bora, we have patience.
Because I just want to show lordship who is the
No,
petitioner before
first tell
lordship.
me, Regional Transport Authority
Yes.
is empowered by which provision of the Motor Vehicle Act?
Lordship is section 68, my lord.
That is permit or?
No, lordship. Transport Authority, 68.
Okay. Transport Authority.
My lord.
Transport Authority.
My lord. May I read, my lord? 68 transport authorities. The state government shall by notification in the official gazette constitute for the state or a state transport authority to exercise the discharge the powers and functions specified in the subsection 3 and shall be like manner constitute regional transport authorities to exercise the and discharge throughout such area in chapter effort as to region, as may be specified in the notification. In respect of each regional transport authority, the powers and function conferred by or under this chapter on such authorities, provided that in the union territories, lordship, the administrator may abstain from constituting any regional transport authority. Now, to the state transport authority or regional transport authority shall consist of a chairman who has had judicial experience or expertise as an appellate or a revisional authority or as an adjudicating authority competent to pass any order or take any decision under any law. And in the case of a state transport authority, such order other person, whether officials or not being more than 4, and in case of a regional transport authority, and such person, whether officials or not being more than 2, as the state government may think fit to appoint, but no person who has any financial interest, whether as proprietor, employee, or otherwise in any transport undertaking shall be appointed or continue to be as a member of a state or regional transport authority. And if any person being a member of any such authority acquires a financial interest in any transport undertaking, he shall within 4 weeks.
Yes.
He shall within 4 weeks of so doing give notice in writing to the state government of the acquisition of such interest and shall vacate office, provided that nothing in this subsection shall prevent any of the members of the state transport authority or regional transport authority, as the case may be, to preside over a meeting of such authority during the absence of the chairman. Lordship, this may be noted. In the absence of the chairman, the secretary may also take the meeting. Notwithstanding that such member does not possess judicial experience or experience as an appellate or a revisional authority or as an adjudicating authority competent to pass any order or take any decision under any law, provided that the state government may, wherein consider necessary or expedient so to do, constitute the state transport authority or regional transport authority for any region to so as to consist of only one member who shall be an official with judicial experience or so and so, revisional authority or as an adjudicating authority competent to pass any order or to take any decision under any law. By rules made in this behalf, provide this transaction of business of such authorities in the absence of the chairman or any other member, and specify the circumstances under which the manner in which the business would be transacted, lordship. Now, lordship, this is the constitution of the RTA, my lord. Then rules, lordship, may kindly have a look the transport rules 2003 for a moment. Six and 7, my lord. Rule 41. Rule 41, sub-rule 6 and 7, my lord.
Rule 41.
My lord. In my books, it's page 26, my lord.
What is the constitution of regional transport authority? Any idea?
Lordship, in the Rule 7, my lord, may kindly have a look. Sub-Rule 7, the state government shall appoint an officer in the transport service in or serving in the transport department of the state government
Huh?
with the secretary of the state transport authority or the regional transport authority.
This, I don't know, this is
Lordship, may kindly have look at my book, 2003 rules,
2003 rules,
Lordship. It's Rule 41, Sub-Rule 6 and 7, my lord, may kindly have.
41. Okay, 41.
My lord. 6, 7, and then the reasons are given in Rule
Member of
42.
the- So, normal common sense.
My lord.
Suppose in a, say, Zilla Parishad,
Lordship.
chairman is the main party, or say the chief executive officer represents the body.
No.
Say for an university, vice chancellor is to be made the party or registrar is to be made the party.
Lordship.
In every academic council or executive council, member secretary is the registrar.
My
Now,
lord, correct.
normal procedure
Lordship.
says that it is the member secretary who is to be, who is to represent.
Lordship.
Chairman having judicial experience, chairman is one thing, secretary is another thing.
Lord.
There is a secretary normally who represents the body,
My lord,
who has the right to sue and to be sued.
my lord. Lordship is
That perhaps argument you have made
Lordship,
like regarding non-implement of the chairman
Lordship.
will not stand.
And Lordship, the other issue that I have raised. with the
Right.
honorable
So
court.
you should raise an issue
Lordship,
which should stand
my lord.
the scrutiny of law.
But-
I don't think that regional transport authority is to be represented by the chairman will stand.
The Lordship,
What is the next ground?
next, your Lordship, the lack of authorization. Who is the petitioner before your Lordship?
How you are making that stand?
And Lordship may kindly have a look, the instruction that I have given, page 10. Before that also, Lordship may kindly, page 5 also, my lord. Page 5. Annex of B. Page 5, my lord, got it, Lordship. I have,
This body,
yes, the member which were present in that meeting, my lord.
that secretary
Lordship.
was chairing the meeting.
No, Lordship, the
Is it
13,
not?
the serial number 13. I am going to show Lordship who is the petitioner before your Lordship. Whether the union has taken any decision to file this writ petition. Who is the petitioner before your Lordship? This is my question, my lord. Because the secretary in the RTA meeting, they were present. The secretary was Bipul Chandra Kalita, secretary MTAZ. Lordship, the serial number 13, my lord. Then Lordship may kindly have a look. The other issues also, other page 10 also, the secretary, the vice president, treasurer, they were also present. And moreover, Lordship, the impediment petition, the transport authority has filed before this division bench's honorable court in the PL number 70, 2016. The secretary has in fact, the president Pulab Goswami has filed this impediment petition, but nowhere mentioned the petitioner is the secretary of the union, and there is nothing whisper about the authorization of the petitioner to file this writ petition, my lord. In fact, they have never approached the authority if they have facing problem. In the order of 28 December also, we have written to the MTAZ. If they have any problem, they have approached the authority for redress their grievance. But they have not filed a representation, neither they approached, my lord.
Now, Mr. Monto, regarding Locus, one issue is, second issue, I don't think that will stand. That regional transport authority is to be represented by the chairman.
Yes,
You have made the members secretary,
yes. To represent.
so that I don't think, but
Yes.
In some documents, this
Yes.
petitioner is not there, some resolution is there and it
Yes,
gets.
well, kindly see, but these are associations, keeps on changing.
Yeah, right.
When annual general meeting helps, new committee comes in.
Ah,
So we have stated that I am the secretary now.
They have to-
Now, so earlier secretary who was there, they may be there. We are not denying that they were
No,
not there.
because it is a registered society, there must be some procedure.
Yes, yes.
So just produce it tomorrow, then all.
Yes,
We'll
my lord.
place it on, let them
My
raise the
lord.
objections.
Huh?
Let them raise the objections. We'll bring it on record if it
My
is
lord.
so. But prima facie to say that I have no locus, when there is a statement made on oath that I am the secretary of the association, it cannot hold water anymore. Prima facie, this is my case that I am the secretary, elected. I am representing. And if I come in with a false
There's nothing
affidavit,
which are in the
court will look
petition.
into it.
Right.
We have to go by the
court will look
records, my
into
lord.
it, my lord.
Secretary, he is saying secretary.
Because the lordship, the impediment petition they have filed before this
No, that
honorable
was-
board in the PIL number
On which
72
day?
in the month of December.
We are in February.
But they have to
No,
state one
eh,
statement,
If he has made a wrong statement on oath,
lordship,
he is to be prosecuted for perjury.
lordship, my lord.
If there is nothing on ground,
The petitioner may
If you
submit the
can
documents,
substantiate your submission
lordship,
that he is not the secretary,
lordship,
then we will dismiss the petition.
my lord,
But as on that, there is a statement on oath,
lordship,
right?
lordship.
And
But-
he is saying, proclaiming that general secretary of the association.
association.
Yes, lordship, that judgment I am relying, my lord. Lordship may
Which one?
kindly have a look. The author is the Rajasthan High Court judgment,
one?
2020.
You have-
Lordship, I have given.
Bombarded with many documents.
No, lordship, that I have given
Ah.
separately. I have given separately.
I appreciate the anxiety of my learned
Right,
young
right.
friend. my lord.
Yes,
Lordship,
tell me.
paragraph 4, 5 and 8 is relevant. 7, 8.
This is a society. Do you have the bylaws?
Yes.
Do you have the bylaws?
Yes, bylaws, registered society must have bylaws, my lord. That is why I am saying, if they want to raise this issue.
No, they have raised the issue.
Let them raise it in
Raised,
writing.
they have raised the
We'll
issue.
place the documents. We'll place the documents. We have given registration certificate. This is a registered organization.
Right, that,
Yes.
so far that question is
My lord, this is-
authority of the association to file the writ petition is not doubted.
But who can represent?
The locus of the person who has represented
Yes.
the association, that has been doubted.
Yes. So let them raise the doubt in black and white. We will come up with all documents as and when necessary. But prima facie, lordship will see whether in a registered society,
No,
any
we are
person can come in.
considering your,
Yes.
it is not that, we are also considering your
Yes,
relief.
yes, my lord. True.
That is why we have to be doubly sure.
My lord, that is why I am
Get
saying.
it tomorrow.
My lord, I am
No,
saying.
we have no problem. Get it tomorrow.
Yes. Yes. Or at two. আসলে আমি আনব পৰা আজি। At
It is
Another issue, lordship,
At
may I
two.
submit?
society.
Is alternative remedy is also available. Alternative remedy.
Whether that body has power to pass any time or.
Yes, my lord. Section 89, my lord. Yes, on 89. In fact, lordship, may I submit another thing, my lord? We are not
Otherwise, otherwise,
Yes,
it appears, see,
my lord.
just for your reply,
Lordship,
suddenly you have stopped, right?
lordship.
But otherwise, say page, section 66. They have obtained the permit
My lord.
because it amounts to suspension of their permit. Say, if they do not say that it is cancellation of permit. Right? Right?
My lord.
Otherwise, they are permitted only to fly the vehicle on a particular specified route and to carry passenger. And permit is given for a definite period,
Lordship.
right?
Lordship.
That is different thing. What is will be renewed or not? That is one
Right.
aspect. The permit is in existence.
Lordship.
I'm not saying about this petitioner,
My
but
lord.
some vehicles.
My lord.
Now, it amounts to almost suspension.
My lord.
Now come to page section 86.
86, my lord.
86.
Lordship.
Right.
Cancellation, suspension of permit.
Subsection 1.
Lordship.
A, B, C, D, E, F.
My lord.
Right. Then
Lordship.
read. Provided.
Provided that no permit shall be suspended or cancelled unless an opportunity has been given to the holder of the permit to furnish this explanation. Yes, it is correct. Lordship, we are not cancelling their permits. Lordship.
Oh, madam.
My lord.
Let us assume
Yes,
their permits are not cancelled.
my lord.
But by this ban,
Lordship.
it is suspension.
Suspension.
Yes, it
We can
amounts to
say
suspension.
Lordship.
And then also you have to give an opportunity of hearing.
That correct, my lord.
And that is not there.
We have given them the notice. If they
What
have any.
notice?
Lordship.
This will not do.
Through RTI or
Random
for
notice
MTAG.
will not do. Blanket notice. Where is that?
Lordship, the order dated 28/12,
Let us see.
page 41 in the writ petition, my lord. Page 41, annex of 4, my lord. We have written to the President Secretary,
Yes.
page 41 of the writ petition, my lord. My lord, we have addressed to the President Secretary, Metropolitan Transport Association, Guwahati, MTAG Lordship, for removal of permit of city buses from their authorized roads. Then with reference to the subject cited above, I have been the honor to enclose here with the list of city buses which have been removed from their authorized roads as per the decision taken on the RTA board meeting so and so. It may be mentioned here that in this regarded meeting was held on 13/12/2023, wherein the MTAG assured to render support. If there is any grievance regarding the matter, one may approach the office of the undersigned through MTAG Kamrup Metro.
So 66. 1 second.
My lord.
Very first line, no owner of a motor vehicle shall use or permit the use of the vehicle as a transport vehicle in any public place, whether or not such vehicle is actually carrying passengers or goods. Right?
Lordship.
If the permit is cancelled or if the permit is suspended,
Lordship.
the whether bus, city buses carries passengers or not, even the empty city bus cannot ply on the road. That has to be remain inside the garage of the owners. Right?
My lord.
That is 66.
Lordship.
Now, we could have understood that you have removed from the authorized route, but we could have understood that you have taken measures to
Yes.
give them alternative routes.
Alternative route. Yes, we are.
Then yes,
Yes, my lord. That's true. We are deciding on it. We are going to give them
not
some
decide,
other
you decide.
lordship. In my written instruction, it is written, my lord. The second page, my lord.
You want allaying of your apprehension about the locus?
Lordship.
Okay, they will produce at 2 or tomorrow? We don't think. Only locus about Debraj Das.
Locus lordship because the receipt
Only
application.
locus about
Yes, my
Debraj
lord.
Das. That's
And-
all.
And the president and secretary both. It is the secretary, I think, no? Secretary, no, secretary. Item number 10. Obligation. Because Doctor, no authorization is given in the writ petition, no authorization, nothing is mentioned. Obligation.
May I please?
Yes, sir.
In this matter, Lordship, petitioner was handed over the fishery after 192 days, Lordship.
Huh? Fishery?
Fishery, Lordship. Very limited issue, Lordship.
Issue is limited, whether this court has the roster or not.
Bench four like that.
Huh?
Bench four.
Mr. Sharma, I think you are appearing fishery matters.
Yeah.
In which bench it comes?
Bench four.
Settlement of fishery. So this fishery matter comes under bench four. What is your case?
Case is very limited, Lordship. Not regarding.
Regarding their possession was handed over later on. After this lordship used to dispose it of by.
Representation is there, Lordship.
Okay.
It can be disposed.
Yes, Mr. Sharma,
It can be
what is
disposed.
your case? Moldar, Bar Monoha, Mean Mahal. Till by the respondent for a period of 7 years. Okay, from 1/4/2023.
Lordship.
Yearly bid value. Agreement on 10/10. As per terms, therefore, is entitled to get exemption of paying revenue of Nigeria, for which is subject. You have already paid the entire money.
Enter money, 11 lakh, more
Let
than
him
11.
consider them.
Yes, we'll consider.
Okay. You have been selected after a bidding process.
Tender process.
Okay.
Tender process.
Heard Mr. M.K. Hussain, Learned Counsel for the petitioner. M.S. S. Sharma, Learned Junior Government Advocate Assam for the respondent number 1. And Mr. P. Sharma, Learned Standing
I
Counsel.
will appear for all the.
Okay. Your state council also? Oh, sorry. Okay. Mr. P. Sharma, Learned Standing Counsel, Fishery Department and AFDC for all the respondents. The case of the petitioner, in brief, is that pursuant to a competitive bidding process for settlement of Bar Monoha, Mean Mahal, District Morigaon, within the fishery. The fishery came to be settled with the petitioner by an order of settlement.
Is 17.
17.
Lost.
Dated 11/10/2022. Issued under the hand of the Managing Director, Assam Fisheries Development Corporation Limited, AFDC Limited. That is the respondent number 3. As per the settlement, order of settlement dated 11/10/2022, the fishery has been settled with the petitioner for a period of 7 years, from 1/4/2022 to 31/3/2029, at an annual bid value of rupees 6,61,000. Pursuant to the order of settlement, an agreement has also been executed between the petitioner on one side and the respondent, AFDC Limited, on the other side, on 10/10/2022 as per the terms and conditions of the notice inviting tender. Full stop. The further case of the petitioner is that as the petitioner has been handed over the fishery only after 11/10/2022, petitioner should not be foisted with a liability to deposit. Because petitioner should only be allowed to deposit the bid value, annual bid value in proportion to the period he has been allowed to operate the fishery. Full stop. The petitioner has contended that since he did not operate the fishery for a period of 192 days from 1/4/2022 to 11/10/2022, he should be granted exemption from paying any amount for the said period. Full stop. The petitioner has contended that despite he is not operating the fishery for the said 192 days out of the financial year 2022/2023, the respondent AFDC authorities had asked for the entire annual bid value, which the petitioner had also deposited. Seeking exemption. Seeking relief in the form of exemption from depositing the bid value for the period of 192 days from 1/4/2022 to 11/10/2022. The petitioner has submitted a representation on
310, page 20.
3/10/2023. Full stop. As the said representation has not yet been disposed of, the petitioner has approached this court by the instant representation to take demands that the respondent authorities in the FDC are sitting, have not taken any discernible steps to dispose of the representation. So, Mr. Sharma, Learned Standing Council FDC, representing the respondent number 2, 3, and 4, has submitted that since the petitioner has stated that the representative submitted by him on so and so is pending till date, the petition can be disposed of with a direction to the respondent number 3. Respondent number 3?
Yes, Lordship.
To take the same representation on board and after affording pursuing the petitioner to dispose of the said representation within a reasonable period of time. So, Mr. Hussain, and counsel for the petitioner has agreed to the said submission made by Mr. Sharma as technical state. Full stop. In view of the above, in view of the broad consensus arrived at by the parties in the aforestated manner, this court is also considered view that instead of keeping this petition pending, the same can be disposed of. As submitted by Mr. Somala standing of the 8th district, comma, with a direction to the respondent number 3 to take the representation stated to have been submitted by the petitioner before him on
310, Lordship.
3/10/2023 on board. And after hearing, full stop. It is accordingly ordered, full stop. It is further observed that while considering the representation, the respondent number 3 shall also give a personal hearing to the petitioner as regards his payer for exemption of settlement amount for the period of from 1/4/2022 to 11/10/2022, and thereafter shall dispose of the writ petition within as expeditiously as possible, comma, but within an outer limit of 45 days from the date of submission of the certified copy of this order. This order disposes of the writ petition.
Item number 11. May I please? This is the finding of the special tribunal, land grabbing case, my lord. The judgment, your lordship will find, my lord, at page 41, my lord, it starts, my lord. My lord,
41,
my lord. Annexure 6. Yes, my lord. My lord, actually the petitioners and the my lord, complainant and the my lord, respondent, the petitioner here, the brothers, my lord. And my lord, it is a claim of the my lord,
It
petition.
is on the exercising civil one or criminal one?
My lord, though my lord, the finding is, my lord, that the proceeding under, my lord,
Because
I'm liable.
he
to
has both
proceed-
jurisdiction,
Aye, my lord.
civil jurisdiction and
Yes, my lord.
criminal jurisdiction.
Yes, my lord.
So that is my question. That has not been answered
My lord, the
till date.
my lord, here what he has, my
If
lord.
it is civil,
Yes, my lord.
it should be 227 perhaps.
To my lord, civil, my lord. Perhaps it will be-
If it is criminal,
My lord.
if there is no other option because special code is not there,
My lord. So
then
what?
we'll admit the repetition on the repetition criminal. This is my view,
My lord.
subject to your.
My lord, here, my lord, the finding, my lord, you will find at page my lord, 52. What he has, my lord, said that he has, my lord, held us to be land grabbers under section 2D of the act and are liable to be prosecuted for commission of offense under section 4.
That is, that direction will come after finding you as land grabbers
Yes.
on the civil
Yes.
jurisdictional side,
Yes.
right?
Right.
Then that criminal side will proceed.
Yes.
Now it will proceed with
The offense part.
offense part and for conviction and sentence.
Yes.
But this one is, till now it is civil.
Till now it is civil. Punishment is civil. Yes. that's
So,
my lord.
I think this is a case of superintendence, or we can
Lordship can convert
examine.
it.
But so far, I don't think that there should be any interim order.
My lord,
After trial,
trial, my lord. But then Lordship will see the way, my lord, the sketchy allegations, my lord. Disposition, my lord. Lordship will see the allegations that has been made, my lord. Page 18, my lord. I'm just yes,
that
my
is the question now. We are in certiorari.
Yes,
We
I
are not in 227.
I understand, my lord. Lordship can perhaps convert it also, my lord, to
That is, you make an application, CRP, they will do. Because otherwise, what? That one. The judgment, Supreme Court judgment says, if it is Salini Shyam Shetty, if it is 227, it must be registered as CRP, not as.
Right.
And these are some. So make an application, it is up to you.
Right.
But otherwise, we will be exercising certiorari.
my lord.
Manifest error.
My lord.
We will not examine. Appreciate the evidence.
My lord, I understand. But manifest error, that's what I'm saying. my lord. Manifest error in the sense, my lord, the Lordship will see the allegations, they're very sketchy.
Sketchy.
Just merely by saying,
Sufficiency or adequacy of reason is not a case of certiorari. If he has some reason, given some reason, will not enter.
Right.
That is why I need your assistance. This is my view.
My lord.
It has not been brought in black and white till now. This is my view. I think I asked learned additional advocate general, thereafter asked the advocate general also. Then I don't know, that matter is not listed before me. Because I asked,
I'll take
I required their assistance.
My lord.
Additional advocate general as well as advocate general.
Since this question is fallen from your lordship, I examine that issue also, my lord.
And they said that they would come back.
My lord.
Thereafter matter is not listed before me, so I don't know. Right.
Well, I'll simply examine the issue, my lord. Since it's
Okay,
fallen from
Friday?
your lordship. My lord, Friday, my lord.
No, you examine this.
My lord.
If you find that this is a case to be registered as CRP,
My lord.
then you,
Let me find it. Let me find it.
okay, on the prayer of Mr. M. Dr. Lanakal petition, list the case on Friday.
Good luck.
Can you find out from Mr. B. Goswami, Learned Additional Advocate General, or Mr. D. Hoikia, Learned Advocate General, that some queries were asked to them, what they have found? Because that tribunal, special court is not constituted.
Yes, ma'am. The special.
Otherwise, appeal would have lied.
Yes, ma'am.
I asked the Advocate General also, I say that what about constitution of the special court?
Special tribunals.
That he said it would come back. But case is not listed before me.
My lord. I'll look into this.
Item 12.
On behalf of Mr. A. Sharma, he is in bereavement due to
Bereavement.
yes, Lordship, somebody has died, expired in his family. So, but there is urgency in the matter. So, Lordship, there was a building that was constructed, and fifth and sixth floor, they are without permission. Fourth floor was also without permission, that was regularized. Now, FAR ratio is there, so that has not been complied with. So they prepared an appeal, and appellate authority has given an order that it may be, that is at page 25 and excerpt 5. Regarding the extra floors, in the last two paras, they have stated, the appellate authority. The addition of extra floor beyond what has already been permitted is not permissible under the relevant building bylaws. However, the same may be permitted subject to confirming the required FAR and payment of the fee as contained in Schedule 1 of the building bylaws. It is not in dispute that the 2 extra floors is equal to the area permitted in the approved floors. In view of the above, this appeal is disposed of with the observation that the authority in the GMC may regularize the extra floors subject to meeting of all relevant criteria as required under the Guwahati Building by Construction Regulations Bylaws 2014. As
Primarily, this order appears to be illegal. Yes.
Lordship, this item and item number 55, both the petitioners are brother. On the they have buildings on the same plot of land. Initially, they obtained a permission for ground plus 3. They constructed ground plus 4. Thereafter, 5th and 6th. Now, 4th has been regularized. 5th and 6th cannot be, it was, though application was submitted. In the other case, on court's intervention, notice was issued. And demolition of the building has.
Whether this observation is primarily legal in terms of bylaw,
yes.
However, the same may be permitted subject to conforming to the required FAR.
That was the linear.
This bylaw has been interpreted already by the Supreme Court.
Yes. Yes. And according that
addition of any floor is illegal.
Yes, Lord. Lordship, what happened in
this
case?
FAR issue does not come. You have put the cart before the horse.
Because there are 3 brothers.
Whatever,
Have
we are
decided now
testing this member in appeal order. This is completely contrary to.
Yes, doctor. That is why, Lordship, even after that order, Lordship, one subject to provision was there, and the authority decided to
But
not to regularize them.
And that no,
Supreme Court has said this by law.
Yes,
Addition of floor is never permitted under the bylaws.
yes, that is there.
Far is a
Except
different
the-
concept.
now,
We'll issue notice.
yes,
If
Lordship,
you want,
no notice has been,
okay, you argue on interim.
Lordship, thereafter, no notice was served on us. We have heard that notice was issued, but it was served to the complainant itself.
What, when illegality is done, what notice is required?
Lordship, because the other brother,
Tell me any authority that palpable illegality, apparent illegality, or ex specie illegality. Notice
notice can
can
be
be issued.
dispensed with. It can be dispensed with.
Your clear admitted cases, you had no permission.
For fifth,
Fifth and sixth. Yet you had constructed fifth and sixth. It is not that you have extended the setback that between wall and your building instead of 5 feet. Somehow it got 4 feet. It is not a case. Constructing without any kind of permission.
Lordship, that time we prepared an appeal, and thereafter we prepared an
Yes.
application, at least to seal the floors till disposal of the.
Priyanka.
Lordship.
Priyanka. Priyanka.
2010.
Appendix 3.
2010.
Yes, sir.
Because this order in appeal will not make any comment.
Okay.
Will not make any comment.
I've gone through that judgment. I've gone through that judgment.
You have gone through the judgment.
14
Yes,
of them.
Lordship. Yes,
If you pray for interim
14%.
relief, then
Okay, no.
Lordship,
I'll consider it. But if you don't, we'll issue notice,
Lordship.
simply.
what I have prayed is that let these floors be sealed till disposal of this writ petition and no demolition.
No, I'll
then.
consider whole hog. Or otherwise I'll issue notice. only.
Lordship, at this point, because Mr. Anupam Sharma,
We'll issue notice, short notice.
till then at least the demolition will not construct, we can give undertaking.
No, we are not here to protect any illegality. I'm clear.
Lordship, because the setback, only the difficulty.
It is not a case of setback. It is construction of 2 floors without permission. It is not setback. Had it been a setback, yes, your contractor might have done something. Your Rajmistris might have done something, but it is not. It is construction of 2 more floors.
No, Lordship, to what extent it can be regularized, that is also part of the rule, Lord. It cannot be regularized. Additional floor will mean additional floors beyond the compoundable floor, Lord.
Appendix 3, bylaw.
Appendix 3, yes, Lord.
A building bylaws deals with penalties so and so, so and so. However, addition of extra floor falls in the category of non-compoundable items. Thus, in any case, anything that has been constructed beyond 5th floor would be non-compoundable and same cannot be compounded at all. In other words, minor deviations from sanctioned plans should be confined only to FAR permissible, but should not extend to extra floor.
That I have gone through.
I'll put this observation. And decline your interim paper. Because it is not a case. And this appeal order, it is a pliable order. Any more paragraph, Mr.?
No, that is it. So far as interim is concerned,
This court is not inclined to give any scope to Mr. Nayak also. Third, Mr. Ellen Tamoli.
Yes, and
Land Council for the petition. And Mr. Pina, Standing Council, GDD,
And
GMC, for all respondents.
Yes.
Full stop. The petitioner had initially obtained no objection certificate. Had obtained a no objection certificate on 10/1/2019 for construction of a building, Z+3. Page, page. Annexer Roman 2. Full stop. In addition to Z+3, the petitioner had thereafter constructed the fourth floor in the building, full stop, by an order certificate dated 9/6/2020. The respondent number 2 has certified that ZF plus 4 building was regularized by way of receiving penalty so the certificate has further indicated that the fourth floor of the building was regularized by compounding as per Appendix 3 of Building Bylaws. This is Appendix 3.
Yeah, 2014.
Full stop. The petitioner had thereafter, constructed the fifth floor, 2 additional floors, that is fifth floor and sixth floor in the building. Full stop. As a demolition process has been initiated by the respondent authorities, GMC authorities, the petitioner has approached this court by the instant writ petition. Issue notice returnable on 6/3 as Mr. Nayak. The petitioner, we could do extra copies by tomorrow. The petitioner has also made an interim plea in the form of a direction to restrain the respondent authorities from taking any coercive action in respect of the fifth floor and sixth floor of the building constructed by the petitioner pending completion of a process for regularization. Full stop. The petitioner has referred to an order dated 2/9/2023 passed in appeal by a member. One member sits over entire GMC authority as an appellate.
Yes.
Entire GMC. It is not mayor in council.
So far as this order is concerned, Lord, one member,
ASP is generally body.
appellate authority.
Appellate authority.
In this case, Lordship, one member, it appeared.
One member, mayor in council within bracket appeal, has passed an order. The relevant part of the order reaches under read to read order annex of fact. He has observed not permissible.
That is an observation. That's subject to part also.
However, part is dicey.
Yes. That leniency was there.
Actually, they
The appendix Roman 3 of the building bylaws came to be considered by the Honorable Supreme Court of India in Priyanka Estate International so versus State of Assam and others reported in 2010 to SCC 27. Most of the issue in therein was construction of additional course beyond the building permission. Post of in that connection, the Supreme Court, Honorable Supreme Court has entirely observed as on paragraph 40. Paragraph 41. Paragraph 41. In view of the above observations, as the construction of fifth floor and sixth floor in the building is without any permission, and in view of the observations made by the Honorable Supreme Court of India in Priyanka Sopra, the interim prayer is not considered, is declined.
Lordship, one item is there, item 55, Lordship, wherein also one application filed by the present petitioner is pending, same prayer, Lord.
50?
55.
Any interim order there?
He has prayed for status quo order by filing an application.
Is operating. Interim
No,
order is
no interim.
operating.
He has filed an application.
And that is different thing.
No, same with
We
prayer.
have not passed the order.
If that matter
Same
is not
petition.
raised today. Same petition. Applicant is the same, Lord. Read petitioner is his brother, but the IA applicant is same.
For what?
Same for status quo.
I think Mr. Kamuli is not the petitioner.
No, Lordship. Actually, I have appeared today as because petitioner is one of my friend and Mr.
I
Ankit
think
Sharma.
you are not the counsel.
No.
He is not the counsel.
Lordship, here also I may be allowed to submit my Wakalatnama because I have not submitted the Wakalatnama in this case. Suddenly due to the emergency. I have
Submit.
Lordship will take up.
Mr. Kamuli has submitted that he has entered appearance by submitting Wakalatnama today.
for the day.
If that method.
The counsel is not there.
If,
Lordship,
yes,
Come back, we'll come back.
Lordship.
Yesterday, one case was there.
What is that?
This is the murder.
Okay. Do you have the copy of the order?
Actually, in my
What
mobile.
is the read petition?
Next date is fixed on
No, what
19,
is the read petition number?
509.
2024.
That may be tagged, my lord. 509.
509.
24.
Similar?
Similar matter. Actually, this is the mother, that is the son. Actually, three matters were there. One is to become.
And Mr.
DK Nath.
DK Nath. Learned counsel for the petition. MS R. Bora. Learned standing counsel. Learned CGC also.
No, I'm not.
You can represent one also.
Normally, we represent, but assistant, the deputy assistant AJ is directed to take instruction in this regarding appointment of arbitration. So he actually he will take instruction. He was asked to take instruction by 12.
Okay. Ms. G. Hajorika. Learned standing counsel revenue department for 2. MS S. Sharma. Learned junior government advocate Assam for the respondent number 3 and 4. MS R. Bora.
5 and
Learned
6.
standing counsel NHIDCL for the respondent number 5 and 6.
Thank you.
The case of the petitioner is that initially, a part of the petitioner's land along with one existing building was acquired by the Ministry of Road, Transport and Highways for the purpose of widening stroke construction of National Highway. Full stop. As the award was passed,
Yes.
as the award passed under Section 3G 1 of the National Highways Act 1956, were found to be fraught with irregularities, in that compensation amount was not assessed.
Actually, part of the building was demolished, other part was not given compensation. Therefore, that is one
And
part.
compensation was not assessed
Yes.
in respect of
Remaining
a
portion.
part of the remaining part of the building.
Yes.
An application was preferred by the petitioner before the competent authority, land acquisition by the petitioner. Full stop. Thereafter, as no relief was granted by the competent authority, land acquisition, the petitioner moved an application before the arbitrator, appointed under Section 3G5 of the National Highways Act, seeking proper calculation and enhancement of the compensation amount. Also, the said application has been registered as arbitration case number 525/2022. Full stop. The arbitrator passed an order on 2/2/2023. Directing inter alia the competent authority, land acquisition, Kala, to make a joint field verification and to find out whether compensation
But that 11% is at page 35. Last page.
joint survey. In the light of the provisions contained in Section 3G5(7) of the Act 1956. The Commissioner, Upper Assam Division, Jorhat, was the arbitrator appointed by the central government under Section 3G5 of the Act 1956. It is the case of the petitioner that subsequently, the office of the Commissioner, Upper Assam Division, Jorhat, was abolished by the state government by a notification dated 17/7/2023 of the General Administration Department, comma, Government of Assam. Full stop. In terms,
22nd June. Page number
Abolish.
37.
huh?
Page number 37 is the abolition notice.
37. 17,
Sorry, my lord.
38.
Yes. Sorry. 17.
The petitioner has contended that in view of such abolition of the office of the commissioner, comma, Upper Assam Division, comma, Jorhat, comma, there is no arbitrator presently appointed under Section 3G5 of the Act 1956 to consider the case of the petitioner. Full stop. The petitioner has averred that the competent authority, Kala, has, comma, in the meantime, comma, completed the joint survey and after completion of the joint survey, comma, has provided a report to the arbitrator. এইটো লাইন আগতে দিব তাৰ পিছত ইটো দিব অলপ আগতে কোৱা The petitioner has approached this court by the instant writ petition seeking inter alia direction to the respondent authorities to appoint an arbitrator under Section 3G5 of the Act for the purpose of disposal of arbitration case number 25 to 2022. Issue notice to the respondents returnable on 19/2/2024 as so and so appeared. The learned counsel for the petitioner shall serve a copy of the writ petition along with annexes to Mr. R.K. Dev Chaudhary, learned Deputy Solicitor General of India, for respondent number 1. Place the case on 19/2/2020. Okay.
May I please, your lordship, my lord. Petitioners purchased 3 plots of land, my lord, 1 bigha each, my lord. Thereafter, my lord, they got mutated, their name was mutated, my lord. Page 31, my lord. And they have been paying, my lord, the land revenue till today, my lord. But regarding some boundary dispute, my lord, with some persons, my lord, petitioner submitted an application before Circle Officer, my lord, Ajara Revenue Circle, page 51, annexure E, my lord, for a demarcation of the said plot of land, my lord. My lord, though demarcation has been made, but the position of the particular plot of land has not been handed over to the petitioners, my lord. Position of the said plot of land has not been, my lord, handed over to the petitioners, my lord. That is
Page 51, 52.
yes, ma'am. After demarcation,
কিছু লোকে অবৈধভাৱে দখল কৰি ঘৰ দুৱাৰ সাজি বসবাস কৰি আছে।
yes, ma'am. That is some other person, my lord. So, my lord, they have not, my lord, they are illegally encroached the land, my lord. So, my lord,
So, what happened? What is your prayer here?
my lord, all three to, my lord, they hand over the position of the particular plot of land to the petitioners, my lord, by the respondent of the petitioner. For a direction, my lord, to the respondents, my lord, to hand over the position of the.
So your own document makes it clear that this writ petition deserves dismissal at the very beginning.
My lord,
In limine, your page 52 application deserves, you have said that কিছু লোকে আমাৰ দাগত থকা মাটিৰ কিয়দাংশ কিছু লোকে অবৈধভাৱে দখল কৰি ঘৰ দুৱাৰ সাজি বসবাস কৰি আছে। So, you have come before this court. Circle officer demarcated the land.
Yes, my lord.
Then at the time of demarcation, petitioner requested the concerned circle officer to remove the said houses.
Yes.
But the circle officer directed the petitioner to approach the court in this aspect. And hence this petition before this honorable court praying for adequate relief. Yes, Mr. Chauhan, what to do? Is this the court?
Not there, my lord.
Huh? Is this the court?
That is civil court, my lord. That is correct, my lord. But
Then Mr. R.S. Chauhan is preferring this writ petition for what?
just deduction from this. my lord.
Just to make a trial. Circle officer said, your Patalan and your application. আমাৰ দাগত থকা মাটিৰ কিয়দাংশ কিছু লোকে অবৈধভাৱে ঘৰ দুৱাৰ অবৈধভাৱে দখল কৰি ঘৰ দুৱাৰ সাজি বসবাস কৰি আছে। Private Patalan enclosed by private individual. What circle officer can do? He cannot do anything. He rightly advised you to approach the court. Approach the court does not mean you approach the high court.
Yes, yes.
Tell me what to do. Heard Mr. R.S.
My lord, I may be able to withdraw, my lord.
Huh?
Withdraw.
If better sense prevails, it is better. Mr. R.S. Chauhan, learned counsel for the petitioner, has submitted that the petitioners want to withdraw the writ petition. Miss G. Hazarika, learned standing counsel, Revenue Department. MSS Sharma, learned junior government advocate, Assam Quarter, point number 3 and 4, have conjointly submitted that the petitioner cannot seek the relief of the kind they have sought for in the instant petition. Full stop. In view of the above submission made by Mr. Chauhan and counsel for the petitioners, the writ petition is dismissed
It's
on
liberty.
withdrawal.
Liberty, my lord.
Hmm?
Liberty, my lord.
Ah. With the liberty to approach appropriate forum.
Yes. Obliged.
Item 15.
May it please your lordship. My lord, in this case, my lord, the petitioners, my lord, private land, my lord, that a veterinary first aid center has been established, my lord. Initially, my lord, it was supposed to be established on a different plot of land, my lord, to which a gift deed was given, my lord. But thereafter, my lord, they have come to another plot of land, my lord, and they have constructed the first aid center, my lord, first aid center, my lord. Veterinary-
When?
It was done in the year 1987. They have acquired, my lord.
87.
Yes, my lord.
13 plus 24. How much? 37 years.
Yes. But my lord, recently, my lord, they have tried to, my lord, renovate the everything, my lord. And they have not been.
Renovation is one thing. They are in occupation of that particular
Yes,
plot
but this
of
is my
land since
private-
37 years.
Yes, my lord, this is my private land, my lord.
Right.
Since, my lord, another Assam land requisition, my
Whether
lord.
in 1987 they had come with full force and evicted you.
No, they have not evicted, my lord. My lord, may kindly come to my lord.
It is silent enforcement.
Yes, my lord. It was my lord, may kindly come to my lord page, my lord, once. The page, my lord, 23, my lord. The reasons behind, my lord, the gift has been given to that plot of land, my lord. It was a different plot, but now the construction is now in different plot. my lord.
You gifted.
Yeah, initially it
You
was a
gifted
gift.
what?
The gift did,
My
lordship,
lord, the
annexation
gift
deed.
was made on certain different plot of land, my
Tell
lord.
me what gift. It was executed when?
Yeah, it was executed in 1985, my lord.
1985.
Yes, my lord.
How much area?
1 bigha of area, my lord.
1 bigha.
Yes, my lord.
You have gifted to
Yes,
department.
department, my lord.
Okay.
Yes.
Then what happened?
Thereafter, my lord, they have not constructed on the area where the area has been gifted, my lord.
They have got it.
They have constructed a different plot on a different tag number, my lord.
In 1987.
Yes, thereafter, my lord. Thereafter,
1987.
thereafter, 87, my lord, I'm telling, my lord.
And you were looking at the office since 1987.
But there was a condition, my lord. My lord, may kindly see, my lord. Page 23 once, my lord.
You want what?
My lord, I want, my lord, the land
Lo-
today. Yes, my lord. The acquisition.
Chokidar.
Yes, initially, my
If
yes,
you want Chokidar, it is a case of compassionate appointment.
my lord, I am not on today. I am not on that, my lord. Initially, at that stage, my lord, when this land has been taken away from us, my lord, by way of a gift, my lord, it was assured that they will give us a job of Chokidar, my lord. But subsequently, my lord, they have not constructed the building in that area, my lord, in the area which was gifted, my lord. It was in a separate land, my lord. So I am praying, my lord, that the acquisition was not been done, my lord. So I am praying for the acquisition of the land. That is what is my prayer, my lord.
Your 1 biga you have donated.
Yes, my lord.
Plus,
Yes.
as per your case.
Yes.
Plus, agriculture department or veterinary?
Veterinary, my lord.
Veterinary department
Yes, my lord.
had occupied another 1 biga land
Yes, my lord.
and constructed their building,
Yes, my lord.
office building,
Yes, my lord.
there
Yes, my lord.
in 1987.
Yes, my lord.
And since then, they are continuing.
Yes, my lord.
Now they are recently trying to renovate it.
Yes,
That is your case.
Command construction that now. We are praying, my lord, that the acquisition should be done, my lord. Because the acquisitions, my lord, another act, my lord.
Let me try in some other court. I am not inclined to proceed
But the,
any further from this stage.
but my lord, the acquisition act.
No requisition act.
Section 6 of the, my lord, this act, my lord. My lord, may kindly see, my lord. Requisitions can be done by the government. There is no, they can be done at section 3, my lord. But under section 6, my lord, acquisition, the acquisition process has to be initiated, my lord. That is the, my lord, act says, my lord. And there's a judgment to that effect, my lord. That once the government acquire any land, my lord, requisition any land, my lord.
This is a case of basically encroachment.
Government department, my lord, we cannot say because government is, my lord, having the land of the private party, my lord, only on the basis of this act, my lord. Assam land.
Some other place.
My lord.
Please the case before any other event.
Oblige.
I am not inclined to proceed any further from this stage.
Oblige.
There was a gifted 1 biga gone
Now
in 85.
Yeah.
Government is in occupation of your private lawn since
Yes, my lord.
1987.
My lord. Another 1 biga, my lord.
And you are looking at the building since 1987, knowing fully well that they are in encroachment of your private patta land. Everything is barred by otherwise laws of limitation. This is a case of encroachment. And you should seek restoration of possession.
I'm not seeing possession, but I see the equation of that.
We cannot direct requisition, Mr. Hello?
Oblige, my lord.
Try your luck somewhere.
Yes, my lord. Oblige, my lord.
This is new type of case I have argued. before.
New type.
Yes, my lord.
Okay.
This type of.
It will be new also for me also.
Yes, my lord. Because, my lord, in this case, what happened, my lord? My lord, gas pipeline has been go over the land of the petitioner.
Over or below?
Below.
Below,
Sorry, my lord.
yes.
Below the land
It
of
goes
the,
below.
below the land of the petitioner, my lord. And my lord, as per my lord, Petroleum Act, my lord, we cannot.
62.
Yes, my lord. 62, my lord. We cannot use the. You can only use the land, but you cannot permit any permanent construction and other thing in that particular land. That is why, my lord, legislature think, my lord, that this Petroleum Act benefit has been, my lord, given extended through, my lord, right to fair compensation and transparency in the land
Is it
acquisition.
so? Okay, right to fair.
Yes, my lord. 2013, my lord.
Right to
And-
fair compensation.
Yes, my lord. 2013 Act, my lord, it is clearly stated, my lord. If your lordship go to the, my lord, first, my lord, I am cutting short, my lord. Your lordship kindly go to the written statement. What has been admitted by them?
No,
my
first
lord.
13 Act.
Yes, my 2013 Act, my lord.
Huh.
Your lordship kindly look to the, my lord. First schedule, my lord.
First schedule.
Yes, my lord. Your lordship will find page 51, my lord.
First schedule.
Yes,
Petroleum Act.
Yes.
CL number 8.
Yes, my lord. Page 51, my lord. Subject to correction or compensation for landowner, the following concerns are constituted compensation package to be given whose required.
Schedule 1.
Schedule 1, my lord. First schedule.
One schedule.
Page 51, my
Okay,
lord.
okay. One schedule.
Yes, my lord.
Compensation.
Yes, my lord. Market value of the land to be determined as provided under section 26. Section 26, if you also go to the section.
How many, what is the area?
Areas is 41 lesser, my lord.
41 less.
My humble submission before this benefit has been given and they have admitted. They have admitted that as per first schedule, he is entitled for the compensation. If I am entitled for the compensation to the first schedule, my lord, then I am entitled 100% market value of the land with 100% solicium, which has been mentioned in the first schedule, my lord. But they are not giving that benefit, my lord. They want to give 40% benefit, my lord, without any.
Question is, Mr. Chaudhary,
Yes, my lord.
first query
Yes, my lord.
from the court
Yes, my lord.
is okay. Did they acquire your land?
Yes, my lord. They have stated, my lord. Lordship kindly
There
come-
are two things.
Yes, my lord.
Two concepts.
use the land.
I'm coming, my lord. Just the.
There are two concepts.
Yes, my lord.
One is acquisition, many
Yes, sir.
concepts.
Yes, my lord.
One is acquisition,
Yes, my lord.
one is requisition,
One is uses.
right of user.
Yes, my lord.
So whether right of user can be equated with acquisition.
Yes, my lord. That is judgment, my lord. In my
If
lord.
that is so, we'll examine.
Yes, my lord. Notice, sir, lord.
My lord, thing is that, my lord, first thing, they already competent authority has decided. This is the first thing that it should be, as per the PMP Act, the assessment should be done by competent authority. Competent decided they are not entitled again. They accordingly, they preferred an appeal before district judge. District judge also rejected their appeal.
Now, Mr. Chaudhary has raised the question of law.
Yes, my lord.
No, that's what I'm telling you. Law says that he's entitled to get compensation as per PMP Act, and which we are ready to give 40%.
My humble submission is something different.
Better be my saying, instead of with the wasting of time, rather wasting my, that pipeline is already under process of finishing. So this thing will reflect in that area.
No,
We
whether
will not destined for going the pipeline, my lord. Work has
whether
already
they have
completed.
stopped you, any manner,
Let them say, my lord.
to install the
No, my lord.
pipeline. or
No,
whatever.
my lord, they are not stopping problem, but
It
they
is
are
completed
providing
1
the
year
people.
before, my lord.
No, my lord says that so far this act is concerned, act says that they only 10%, I've just read out, my lord. PMP Act, what the PMP Act says,
Somewhere. So his contention is that he should be paid under the 2013 Act.
Yes, my lord. And they have admitted in their written statement.
No,
my
I've
lord.
admitted, I'm ready to give 40% and take it ready and not taking.
But
This is not, my lord. At his whims, my lord, amount shall be paid. He has said, they admitted that I am entitled for the first schedule. First schedule said market value of the land, my lord. And if your lordship go otherwise also, my lord, in respect
My
of
lord,
it is a fourth
another thing
schedule,
is that, my lord, whether this, they have not stated what is the market value. They are silent on that point. What should be the amount of compensation? So,
what is the prayer here?
right, then. Let the matter be remand back to district judge. My thing is,
Why?
let the
He
matter
has
be.
done his part. Only issue is whether they are entitled to be compensated
but
as
that act is
per
there.
2013 Act.
Yeah.
He's saying he has decision in his favor. Do you have any decision in your favor?
Today only I served a copy, so
What
I
decision?
Decision is that, my lord, actually, your lordship kindly go to that act also, my lord, first.
Which
Thereafter I
one?
come. The right to fair compensation, page 81, my lord.
Which one? 2013 Act?
Yeah, 2013 Act itself, my lord. The right to fair compensation and transparency in land acquisition, rehabilitation, resettlement, removal difficulty of the order.
What removal?
Page, my lord, 80.
Huh?
Page 80, my lord.
Removal of difficulty order.
Yeah, my lord. Then your lordship comes to page 81, my lord.
Removal of difficulty order of which year?
2015, my lord.
2015.
Well,
Okay.
earlier
Okay,
2013 Act, my lord,
okay.
2 ordinances come.
Okay.
Yes, my lord. Then your lordship come to the, my lord, page 81. One, my lord, 2. Now, have your lordship got it now, therefore, in excess of power conferred. And by section 1 of section 130 of the right to fair compensation, transparency, land acquisition, rehabilitation, resettlement act, the central government hereby make the following order of the aforesaid difficulties, namely, the order may be called to right to fair compensation, land acquisition, rehabilitation, resettlement. It shall come into the first day of September 2015. The provision of right to fair compensation, transparency in the land acquisition, rehabilitation, resettlement act relating to the determination of compensation in accordance with the first schedule, rehabilitation, resettlement in accordance with the second schedule, and the infrastructure amenity.
Shall apply
Yes, my lord, shall
to
apply.
all cases of land acquisition. Your
Acquisition?
case is by
That's
no
what I'm
stretch.
saying, my lord.
By no stretch.
No, my
In a
lord.
case of land acquisition.
No, my last line, my third schedule shall apply. And acquisition and under another fourth schedule under the act.
See, Mr.
Yes, my lord.
Chaudhary,
Yes, my lord. And
that
acquisition,
sometimes
rehabilitation and
the
resettlement.
Supreme Court has dealt with this issue.
Yes,
Sometimes in laying the pipelines,
yes, my lord.
at some distance, they have to make some houses, pump houses, something like that.
Yes, my lord.
And for that, they have to acquire land. Right. If some pump houses of permanent nature is required to be constructed,
Yes.
then they have to acquire the land. And in that case, these provisions of 2013 would come. But laying down the pipeline below the ground level
Yes.
does not make it a case of acquisition.
I'm
It is
not
a case of right of user.
Rehabilitation and
Yeah,
resettlement
we'll
act.
issue notice at this stage.
Issue notice, my lord, I shall also.
These are interesting issues, notice, my lord, but this can be disposed of, my lord, but it is clearly given in the act.
No, it doesn't.
Act says that like this. I would underline that below, red line. How the compensation has to be paid in the case of PMP Act. And as per this act, I have to, that's my guide. I have to follow the guidelines followed by this act. The legislature enacted this law for the benefit of the.
Okay, we'll examine on the admission stage. At this stage, he is not asking for any interim prayer.
No, my lord.
But
No, they have interim prayer in that.
Bargaining,
That
they-
They have had interim prayer there.
Huh?
They have interim prayer there.
he's pressing.
Yes,
Are you pressing?
My lord.
Pressing, then I'll consider on merit.
He said, my lord,
Oh.
there's no objection for interim care, my lord.
No.
He said it.
no, I'm not
I am
saying.
not
No,
pressing.
You're not pressing.
Yes, sir, he said,
If
my
you
lord.
press, I'll pass. Order.
Landed friend has said, my lord. I
Not
am not
Mr.
saying.
NNB Chaudhary, Learned Counsel for the petitioner.
The lordship will not say anything about this interim care, my lord. Only notice shall go.
No, if you insist, then I'll pass order.
My landed friend said, my lord. I
And
never
Mr.
said.
Mr. Mitro. Yes, Mitro. Learned Standing Counsel Gale. Learned Standing Counsel Gale. Gale. 1. 5. 6 also or not?
Today I've been just.
Union of India.
Indian.
Mr. Gogoi, you can appear for your central government council? No. Any central government council? Mr. MS, who is revenue? Revenue. Z. Hazarika, Standing Council Revenue.
3 and 4, 5 will represent.
For response number 2, Mr. H. Sharma and additional senior government advocate Assam for the respondent number 3 and 4. Any central government council? The petitioner whose land, whose parcel of land has been utilized, is being utilized by the respondent. Who utilizes? GAIL utilizes or Union of India?
Gail, man.
Huh?
Gail,
By exercising the right of user under the provisions of the Petroleum and Mineral Pipelines within bracket acquisition of right of user in land bracket close Act 1962, comma, has preferred this petition seeking compensation under the provisions of the right to fair compensation and
Well,
transparency
actually,
in land
well,
acquisition,
understand it's not correct,
rehabilitation and
madam.
resettlement Act 2013, containing that the right of user
Actually, extra act, my lord.
is
Acquisition, my lord. That's the way I've got, my lord. Application for acquisition of the land. That notice which has been given in page 44 for acquisition, my lord.
Of right of user.
No, my lord. Publication for acquisition. T1. Your lordship kindly go through the
Acquisition
T1.
of right of user.
T1, my lord.
Man, it is already the undisputed.
T1.
Yes, my lord.
T1 is right of user. Act.
Application for
Already
notification for
decided, this is
acquisition.
already decided matter.
Whenever it appeared to the central government and necessary interest for the transport petroleum from one
Sir,
locality to,
Chaudhary, concept is quite clear
but what has been used acquisition?
that it is necessary in the public interest for the transport of petroleum from one locality to another locality may be laid by the so and so. For the purpose of laying such pipeline, it is necessary to acquire the right of user.
Acquire.
Acquire the land, no, not the acquire the land.
They acquire the right of user.
Acquire the right of user.
Ne-
Every word has significance.
Yes, my lord. Next time I will go. Acquire the right of the user.
Acquire the right of user. Acquire the land. No, it is not that.
Yes, my lord.
Issue notice returnable in 4 weeks as so and so appears, so and so. The concept of the petition shall serve a copy of the petition along with annexure, comma, to Mr. R.K. Devchowdhury, Lanet, Deputy Solicitor General of India for the respondent number 7 within 2 days. Extra copy is 2 days. As name of Lanet Standing Council, Revenue, and Deputy Solicitor General already there. Revenue be respected in the respondent side in the cause list.
Item number 17.
Husband died. SI Akan. Excelsia.
Yes, Lord.
Z Hazari. Revenue 1. Any finance? Mr. B. Chaudhary. Finance? B. Chaudhary. Representing Mr. B. Gogoi. Land Standing Council. Finance Department for respondent number 2. H. Sharma. Additional Senior Government Advocate. Assam for respondent number 3, 4, and 5. Who died?
Husband of the petition.
Husband of the petition died on
17/12/2020.
17/12/2022. 2020. Notification at the public press. Notification 15/11/2014. As so and so appeared, accepted. No formal notice. Extra copies by within 2 working days.
Yes, deeply.
4 weeks.
Item number 18.
May it please your lordship.
Yes.
Petitioners are in possession of the land for 32 years. And they filed an application before this settlement officer Dhubri and Kokrajhar. But that application is not acted upon till date.
Is this a proper application?
The application
Annexure
is-
3.
Yes, Annexure 3 is the application.
Is it the kind of application required to be filed
Believe so.
This is,
Believe so.
no, we believe so will not do. There is Kabuliyat.
Where is my lord?
Kabuliyat. Green Kabul. Green fund volume. Volume 1. Everybody will come saying that this application is filed, is considered. We are not into consideration business. So your bona fide, look
But,
at,
they have filed,
to get
they have filed
settlement
during,
or allotment?
for settlement, allotment.
Settlement,
My lord.
allotment.
Allotment.
Okay, under what policy? You are
They,
entitled.
they filed this application, when the
Kabula.
Basundhara scheme
Application
was-
for settlement of wasteland, Kabula. Right. Now tell me under what provision of land policy you should be considered for allotment or settlement of
They
wasteland?
Actually, they filed this application while the Basundhara, the scheme is active. So,
Basundhara is to be filed online.
Land policy 2019.
okay.
Is it not?
That is,
Basundhara is to be filed online.
but during that period, they have filed actually, that application.
That will not do. We will not come up with something. Your entitlement to be settled with land under the land policy.
Mhm.
Under what provision you are eligible? Tell me. Mere encroachment of government land for 32 years
Yes, my lord.
does not make you a bona fide
Mhm.
occupier.
My lord.
An encroacher is always an encroacher.
Mhm.
What kind of revenue you are paying?
No document related.
No
to
document.
Like,
Not even Toji Bahira. Now which has been
the grievance is that they,
renamed as Bedokholi Jorimona.
the grievance is that, my lord, they have not acted anything upon this application.
Not even
For
Bedokholi
that-
Jorimona also. Mr. Sharma, what to do with this kind of application? Adding a number to the docket. Come up with something. This will not do. You are not paying even Bedokholi Jorimona.
Yes.
Will not pass any order for consideration of your application. You are in occupation for 32 years.
Mhm.
Show me some document. You have simply annexed that application and has come before this court. Notice is not even issuable in such type of cases. You come up with better some documents.
My lord, much obliged.
Very close. We'll give you liberty.
Lordship, that will be better.
Maybe we
Better
can.
come up with something more. So
Well-
that we can at least draw an inference that you are in occupation of some land. And authorities are recognizing about your occupation by collecting Bedokholi Jorimona.
Lordship.
And if it shows that land policy shows that yes, there is provision, if you are in possession of khas land
Hmm.
for 15 years, your case should be considered.
Lordship.
But with this kind of application, I am not.
Well-
Mr.
W.A. Sheikh.
WSA Client Counsel for the petitioners has submitted that the petitioner want to withdraw the petition with the liberty to file a press with better particulars. Mr. H. Sharma,
2, 3, 4, and 5.
G. Hazarika, Revenue 1, H. Sharma,
2, 3, 4, and 5.
2, 3, and 4, and 5. No objection to the above prayer for withdrawal in view of the above submission made by Mr. So-and-so. Land Counsel for a petition, the petition is dismissed on withdrawal with the liberty as prayed for.
Much obliged.
Item number 19.
Please, Lordship. Lordship, a commercial suit was filed in Nalbari.
Commercial suit.
I was carrying on my business at West Bengal. And some people come over to my factory and they say that they have court orders and they interrupt my business.
Court order, commercial is where?
Nalbari.
Nalbari. What kind of petition is this?
Lordship, this is a 226 and 227 petition, particularly because Commercial Courts Act says that under section 8, no revision application shall lie in commercial suits. So that is why I have to name the petition as writ petition. Because section 8 bars revision and section 13 says in specific cases appeal can be filed, and that is not my case. So I have no other remedy other than filing a writ petition, Lordship. Now, there are several irregularities during the proceedings, Lordship. The commercial suit was.
Then it will be 227.
But because of the nomenclature, Lordship, it says civil revision petition, CRP. And section 8 says no revision shall be entertainable. Commercial Courts Act, if your Lordship may look into. Commercial Courts Act 2015. If I may please read, Lordship. Notwithstanding anything contained in any other law for the time being in force, no civil division application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction, and any such challenge subject to the provisions of section 13, that is appeal, shall be raised only in an appeal against the decree of a commercial court. So to avoid the heat of section 8, Lordship.
It is, civil division is governed by
115.
115. 227 is different.
It is supervisory jurisdiction, Lordship.
Right.
But because of this terminology, Lordship, revision, it causes some kind of confusion. So to avoid that hit, even if there is a 1% remote possibility, Lordship.
Yes.
And it can still be entertained in 226, Lordship. Because these proceedings are being carried on in an illegal manner, Lordship, arbitrary, total arbitrary manner.
No, this is a self-contained code, right?
Lordship.
If provision is there, suppose to file, if avenue is available, file a petition as CRP under 227,
Lordship.
then why will exercise 226? It is somewhat though thin, it is compartmentalized, otherwise 226 and 227. So no civil revision means we generally indicate that it is 115.
But then our 227
Shall
jurisdiction.
be entertained against interlocutory order of a commercial court.
So perhaps because that leaves me with no other remedy, Lordship, except 226.
I am not fully aware.
In this case, I appeared before the commercial court in Nalbari. I'll have the instruction, my lord, because against any order of a commercial court or a judgment, there is also a commercial appellate court constituted. I'll take the instruction from the registrar.
I am aware of the commercial appellate court because I have been notified as one of them.
Yes.
About that I know.
Yes. Well,
because that commercial appellate bench consists of Honorable Justice K.R. Surana and myself.
Yes. And my lord, in fact, this case which my learned friend is representing, this is the first commercial suit filed in Nalbari.
Okay, Nalbari. We decided about commercial suit first in Kamrup. There was only one appellate petition.
Yes.
Till date before this High Court.
Yes.
So we decided that.
Yes.
But I am still not accustomed with all the provisions of the Commercial Courts Act.
Yeah. My lord, if my friend probably is from outside.
No, he is from here.
No,
He is from here only.
I'm sorry. I've become old, I suppose. I'm not. So whatever be it, my lord, let it have it after next week. If it's not
Monday.
Monday will be fine.
Monday. Then I'll have the proper.
Let me have the look also at the Commercial Courts Act also.
Yes.
These are new acts.
Lordship.
And we are not handling many cases.
Yes, but now in Kamrup.
You enter appearance for whom?
For the respondent number 2.
Okay.
Private respondent. I will serve extra copy, Lordship.
Heard Mr. D. Saraf, Land Counsel for the petitioner. You are through KBN?
No, man. But I was just looking into it because we did not anticipate that a writ petition will be filed. So, my lord, my presence today may not be recorded. Your lordship will I'll come up with the proper instruction on Monday. Because my assisting counsel is out of station.
Mr. H. Sharma, learned for one. Additional senior government advocate, Assam for the respondent of one. Full stop. Raise the case on Monday, again on Monday, in the motion call.
Monday.
That we consider on Monday.
Well, motion call, we are not observing anything. We are not foreclosing here.
Yes.
Lordship, there was a time being matter. Mr. Kyal is here.
Let us complete the motion, then we'll
Lordship.
go back.
Oblige, Lordship.
Whatever is remaining.
Item number 51. Sub the list.
Yes.
My lord, first the nearby village were issued an eviction notice. They came before this honorable court, your lordships interfered with the order of eviction. My lord, your lordship, I'll serve in the copy. Then I belong to the nearby village, same order has been. Paragraph 2.1, your lordship has dealt it with the notice.
Lordship, may I pray day after tomorrow, as because Lordship, our name is not shown, file is not
No
available.
coercive. Monday, you will be appearing in the other case on Monday. No coercive action.
Yes. Yes.
Apparently, it is without jurisdiction.
But Lordship, our name is not shown, that is
Yes,
why I
yes.
mean.
No,
Our Mr. B.D. Kaur, senior counsel assisted by MS. P. Soren. Learned counsel for the petitioner. Ms. G. Hajurika, learned standing counsel revenue for the respondent number 1. Mr. H. Sharma, learned additional senior government advocate Assam for the respondent number 2 and 3. Full stop. The petitioners have approached this court by registering the petition to assail a notice. Notices, comma, all dated 28/12/2023, comma, issued under the hand of the Assistant Settlement Officer, Balijana Revenue Circle, Gwalpara. So, Saveri is the case of the petitioner that the Assistant Settlement Officer, Balijana, an Assistant Settlement Officer has no authority and jurisdiction to issue any notice for eviction under the settlement rules framed under the Assam Land and Revenue Regulation 1886. So, Mr. Sharma, MS Hajurika and Mr. Sharma, Land Counsel appearing for the state respondents, have sought listing of the case on Monday. List the case accordingly on Monday, having found force prima facie in the contention of the learned senior counsel for the petitioners. It is observed that till the next date of listing, there shall not be any further action in terms of the impugned notices dated 28/12/2023.
Lordship, our name may be shown in the positive.
The name of, that's all. The name of
G. Assam Lordship will do.
G. Assam be reflected in the respondent side in the clause. This, you have received copies?
Just now, Lordship.
Deep level.
52.
May please, my lord. Lord, hearing the petitioner, there is a plot of land, a commercial market complex in Gwalpara district.
Before my learned friend starts, Lordship may kindly come to page 3. Most probably this writ is not maintainable.
Where is the division bench judgment then?
Page
Some
3,
division bench judgment, that's
respondent number 1,
it appears.
state is not a party.
Because the district commissioner has interfered this.
District commissioner does not have any authority to represent the state government. I think that is division bench somewhere
Lordship,
laid down the law. I forgot.
I have also.
That's
Do we
why-
have, please get
Lordship,
it,
Lordship, I
because
see.
sometimes we receive
Lordship.
repetition. We fail to make the land council understand. If I
Lordship.
hand it
Lordship,
over
I-
a judgment, then
Lordship.
they
I will find
understand,
it out.
otherwise they will continue arguing for that, on that aspect.
That's why I have not impleted the state, my lord.
Without this state read line over it, no?
A repetition is to be, that is
The
the,
state of Assam I have not impleted.
now
but
now
district
you are
becomes
arguing,
under Article 12.
you are making submission,
My lord.
but division bench somewhere already
Right,
laid down,
I'll find.
My lord, my lord.
because state has to be represented, that is what. Find out, Mr. Sharma,
Lordship.
continue.
Lordship, I will.
If he makes a preliminary objection, I have to examine.
My lord.
Non-maintainability.
Right.
If the maintainability aspect is over, then entertainability.
My only humble submission is that under Article 12, district commissioner would be a state, but not the, I have not impleted the state of Assam, my lord.
Mr. Sharma, then you better,
Lordship.
other will issue notice.
Lordship,
Better
Lordship,
get hold of that decision.
Lordship. Day after
Come
tomorrow-
back, the district commissioner cannot represent the state. And a repetition impleading only deputy commissioner is not maintainable. Come up with that.
Lordship. Day after tomorrow.
On the H day as the Learned
My
Council for the petitioner and H Sharma, Learned State Council. Heard. A list as sought for by the Learned Council for the petition is the case on Monday in the, sorry, Friday, in the motion.
Much obliged.
Item 53.
A decision was there in that context that one executive engineer or somebody file a petition before the division bench. Then in that context, this executive engineer, superintendent engineer, chief engineer, they cannot represent the state. Likewise, district commissioner.
Lordship.
I think that is. Yes, madam.
Lordship, tomorrow is the date of election, my lord. 8 to.
All right. That day we declined one interim pair. Modus Sol Mari. This looks familiar.
My lord.
Many petitions have been
Lordship.
are filed. What to do? I think.
Petition is absent, Lordship. Second half, Lordship, may take up.
Connecting item number.
Obliged, my lord.
Lord, in this case, my lord, we have filed on I, my lord. Inadvertently, my lord, paragraph 3, my lord, we have made that the district commissioner represented by the state of Assam. It is not, my lord. The state of Assam represented should be by chief secretary. So chief
Oh,
secretary
you
will
have
be responsible.
corrected.
And that, yes, therefore we have
Okay,
filed
you have
I.
corrected. Okay, I have to make it.
That is on last listed on 9/1/24, my lord. At the time of issuing note.
Then we have to allow this person. Yes, Mr. Sharma. An interlocutor application seeking implement of state of Assam represented by
Chief secretary.
Chief Secretary.
Yes.
Earlier he
District
Lordship,
Included?
same-
district commissioner.
Same
Same
thing.
situation arises. Lordship.
I heard Mr. P.K. Dekal and counsel for the applicants, the state petitioners. And H. Sharma, Land Additional Senior Government Advocate, Assam for the opposite party number 1 to 3. First up, Mr. The instant application, interlocutor application has been filed. Seeking implement of the following party respondent.
Yes, please.
Further 6 to Likidibo. As party respondent number 6. The state of Assam represented by the chief secretary. to the government of Assam. Dispur, Guwahati, 06. Post of it is averred that in the connected writ petition, WBC number 191/2024, the applicants had inadvertently omitted to implement the proposed party respondent as a party respondent in the area of respondents. Mr. Sharma, additional senior government officer. Assam has no objection to the prayer made in the instant interlocutory application. Full stop. The instant interlocutory application is hence allowed for implement of so and so aforementioned authority as party respondent number 6 in the connected writ petition WBC number so and so is allowed. The learned counsel for the petitioner, applicant petitioner, shall file amended memo in terms of the notification dated so and so before the registry tomorrow, by tomorrow, day after tomorrow, by let to DDO. The office to list the writ petition. They are according. In a motion column. Deep replacement. Yes. Oh. Yes. Kyle is available. Come.
I've talked to the officer, but I have not received any written instruction. Not say may remand back the matter to the.
No. Firstly, I'll issue notice. You are available, both of you. 19.
Yes.
19. We'll pass an order.
Not.
In the meantime, we'll keep this in abeyance.
Not.
It appears prima facie.
Yes, sir.
But we'll issue notice.
That-
These are of the counsel for the petitioner. A.K. Dotto, Central Government Council for the respondent number 1, and Mr. S.C. Kyle, Standing Council GST for the respondent number 225. Full stop. The petitioner has received the instant writ petition assailing an order
23.
in original
23.
dated 23/11/2023 within bracket Annexure F. Full stop. The main ground to assail the writ petition is that the authority, adjudicating authority, had misconstrued the provisions contained in Section 9 of the General Clauses Act 1897 to calculate the period of 30 days from the appointed day.
Yes.
Because the petitioner has submitted that the appointed day was 1/7/2017 and the necessary compliance was made by him on 31/7/2017. So stop. Issue notice returnable on 19/2. 19/2. That Saturday.
Yes, sir.
Will you be available?
Yes, I'm.
Okay. 19/2. As so and so appeared, accepted notice, no formal notice, extra copy by Friday. Having regard to the provisions contained in Section 9 of the General Clauses Act 1897. This court is of the considered view that the petitioner has been able to make a privacy case for interim relief. Full stop. Accordingly, till the returnable date, the impugned order in original dated 23/11/2023 shall be kept in abeyance.
Lots.
17. I'm sorry, 17. 17.
Number 9.
Milord, I would like to forward the proceedings. Lordship will find there was a change in the committee. Proceeding to Diva Mule. This is the original proceeding book. I am giving your lordship the relevant portion photocopy.
Copy also be handed over to MS Bora also.
Lordship, I have received also instruction.
This was the meeting dated 4th January 2024. Proceeding.
নতুন কমিটি গঠন।
Yes, নতুন committee গঠন. It is, Lordship will find the নতুন committee at
Okay.
Prastav Go. That is new committee came up. Old committee resigned. So authorizing everybody to do anything, this is there. So I pray, my Lordship will put a hold on the order so that because it will be for the public interest. Public is not getting sufficient communication. Now buses are not available on the route. All nearly 150 buses are now off the routes.
For that, they have the expertise. We don't know.
Yes, my lord, we may visualize the situation, my lord. Suddenly all these buses were withdrawn from the route. What would be the plight of the commuters?
Lordship may kindly have a look the latest instruction that I have received just now. The 6th January letter is a complaint, my lord. And Lordship, after that, Lordship may kindly have a look the bunch of instruction that I have produced. Page 16, my lord. I have designated the latest minutes of RTA. It is 3rd of February 2024.
Is
It is a start from page Lordship 14, but relevant portion is page 16. Point number 5, my lord.
point number
5, my lord.
5. Is there any requirement?
Yes, the earlier committee, the DC has issued a notification for formation of the earlier committee. This is the notification under the Deputy Commissioner, my lord. This is the process, my lord.
Otherwise, it is a society.
Society, but this is the notification issued by the Deputy Commissioner, my lord, who is the chairman of the RTA.
What is the requirement for this kind of notification?
Lordship, Rule 43, Lordship, 2003,
Rule 43.
my lord. My book, Lordship, is page 27.
Rule 43, yes.
Conduct of business of transport authorities, my lord. Lordship has got it, lordship. Subject to the provision of the act under these rules and also subject to the approval of the government, the state transport authority or the regional transport authority, as the case may make bylaws to regulate and conduct its business, and if the business of such authority shall be conducted accordingly. This is written in the rules also, my lord. And moreover, my lord, I have spoke to the authority in the break time, my lord. They are going to adjust the buses in some other routes. We are not suspending or not terminating their permits, my lord.
Right.
Soon, my lord.
Right.
Well-
I'm not saying that they are cancelling it, but there is a process by the statute itself, that is Motor Vehicle Act. Right.
My lord.
So one authority cannot override the provisions contained in the Motor Vehicle Act. He has to act and abide by the provisions of the Motor Vehicle Act.
Yes, ma'am.
And putting this vehicle
My lord.
out of the system
My lord.
without any kind of notice to the individual
Individual. that
permit
is-
holders amounts to suspension of the permit. Otherwise, permitted them to run the stage carriage up to a certain period.
Lord said. Also regarding that, I have spoke to them also. They said because the,
See, if you have come up with alternative routes
my lord,
with a proposal to the owners, yes, we can understand
my lord,
pollution.
yes, my lord,
From the standpoint of pollution,
Carbon.
you want to replace. But since a permit has already been issued
my lord,
to the owner of the bus,
Lord said.
I think he should be properly rehabilitated in the sense that he should be given some alternative routes.
Yes, that will be given, my lord.
That will
But
be given means,
when the letter dated 28th December, my lord, we have written to their union, secretary and president, but they have not take any steps regarding their
in
grievance.
the meeting, it appears that their representatives were absent.
28, lordship may kindly have a look the
Let
interview
us
letter.
28, let us see 28.
Page
Part of
41, I
this-
think. In
Part of this repetition.
my lord, page 41, my lord. I think page 40. Yes, my lord, page 41.
Page.
41, annex of 4, my lord. This notification, lordship, is the outcome of the cabinet decision of 2021 and the subsequent RTA meeting. This decision was not taken in a day, my lord. It is the outcome only.
Ms. Bora,
My
cabinet
lord.
decision is available for everyone to read.
Lordship, this RTA meeting, lordship, it was discussed.
Cabinet decision 2008-2021.
Yes, lordship. Because the subsequent RTA meeting, lordship, their authority was also present. And in that meeting, it was discussed. The RTA meeting.
Your is stage carriage permit. Stage carriage permit.
Yes.
Stage carriage.
We have given few model permits at page 71, 72 of the plan. In every permit, they specify the route and the period also, page 70, lordship may see. This permit is at page 70, my lord. The stage carriers permit at the top fourth line. And then,
Stage case permit are of two kinds perhaps.
yes, permit in respect of stage carriers permit mini city bus. At top, my lord. That line for up.
Whether it, it comes under section 76.
Yeah, stage carriers.
76.
76, yes, later. Stage carriers.
Okay.
Well, so for application for stage carriers, lordship will find it is section 71, grant of stage carriers permits, 72. Subject to the provisions of section 71, a regional transport authority may, on an application made to it under section 70, grant a stage carriers permit in accordance with the application or with such modifications as it deems fit, or refuse to grant such permit. Provided
Where is your permit?
well,
One sample.
the sample at page 70, 71, 72.
70.
We have given model tube up to 73. Yes. So all these, the period has been specified. Route has been specified. How many passengers I can carry, how conditions are there. I am to abide by, otherwise I am liable to the penalties.
Where is your impugn annexer 4?
41.
40.
41, just lordship had a look on that at page 41.
Right. Mr. A.K. Mohanto. Learned Senior Counsel assisted by MS and Begum. Learned Counsel for the petitioner. And MS MD Bora. Learned Standing Counsel Transport Department. For all the respondents.
My lord.
The petitioner herein has stated that it is a registered association of bus owners of Guwahati. And it is registered under the provisions of
Society registration.
you're not annexed society?
Society Registration Act.
Under the Societies Registration Act, 1860. Provide registration number. Page 30. Provide registration certificate of registration number so and so, with validity up to 15/6/2026. Full stop. The petitioner has stated that the association consists of around 250 members. And the members of the association are having valid permits under the provisions of the Motor Vehicles Act 1988 as amended in the form of stage carriage permits to run mini city buses, city buses in different specified routes within the city of Guwahati. Full stop. The petitioner has further mentioned that the association is formed after merger of 4 other bus owner associations. Full stop. In this writ petition, the petitioner has assailed a notice dated 28/12/2023, Annexer 4, issued under the hand of the respondent number 3. On the subject, page 41, removal of permit of city buses from their authorized routes. Full stop. By the said notice, in the said notice, comma, a list of city buses, a list of registration numbers of 200 city buses is enclosed. No, in the said notice, by enclosing a list of a list of registration number of city buses, mini to Katidu, comma, it has been directed that those city buses have been removed from their authorized routes as per a decision taken in the board meeting of the Regional Transport Authority, Kamrup Metro, held on 20/12/2023. Full stop. A reference has been made in the said notice of another meeting, held earlier on 13/12/2023, wherein indicating the presence of the representatives of the petitioner association, it is mentioned that the representatives of the petitioners association in the said meeting assured to render support to the decision to be taken by the Regional Transport Authority, Kamrup Metro. Full stop. By the said notice, the petitioner association has been requested to remove the minibuses whose registration numbers are mentioned in the enclosed list, from the authorized routes from 1/1/2024 onwards. Full stop. Mr. Mohanto, learned senior counsel appearing for the petitioner, has submitted that though the members, representatives of the petitioner association attended the meeting of the Regional Transport Authority on 13/12/2023.
On that day, we raised certain queries only. We
Hmm.
never agreed. But they did not
Comma.
discuss.
The representatives of the petitioner association raised many issues, including 3 issues
Mentioned there
mentioned
in the proceeding.
in the minutes proceedings of the RTA within bracket Annex 3. But an action taken by the impugned notice dated 28/12/2023 was not an agenda in the said meeting held on 13/12/2023. Full stop. To assail the manner in which the city buses, 200 number of city buses owned by the members of the petitioner association, have been stopped from operating in the specified routes indicated in the respective permits, Mr. Mohanto has referred to the provisions of section 68, 66, section 72, and section 86 of the Motor Vehicles Act 1988, apart from other provisions contained therein. Full stop. It is his submission that stopping the 200 number of city buses from operating in the specified routes, mentioned in the respective permits issued under section 66, would amount to suspension of those permits, whereas the duration of the permit, all those permits are much beyond 1/1/2024. Full stop. Referring specifically to the provisions contained in section 86 of the Motor Vehicles Act, he has contended that no permit can be suspended without providing any prior opportunity to the holder of the permit to furnish his explanation. Full stop. MS Bora, Standing Counsel, Transport Department. Your preliminary objection should be recorded.
My lord,
Has raised preliminary points on the maintainability of the writ petition. Full stop. According to MS Bora, firstly, it is the Regional Transport Authority which has taken the decision to withdraw 200 number of city buses from the specified routes WEF 11/2024. Full stop. The RTA ought to have been represented by the chairman, by its chairman, not by the district transport officer and secretary, not by its secretary. Full stop. And secondly, comma, the person representing the petitioner association does not have any locus standi to file the instant writ petition on behalf of the petitioner association, in that he is not the secretary of the petitioner association as on date. Full stop. MS Bora has further submitted that the decision to withdraw 200 number of buses has been taken after much deliberation and the decision has been taken after a series of meetings of the RTA. Full stop. One of the purpose behind withdrawal of 200 number of city buses, one of the reason behind withdrawal of 200 number of city buses is introduction of e-buses
E-buses, my lord.
on those specified routes, which, comma, in turn, comma, will reduce the adverse effect arising from pollution.
My lord.
Good.
Or semi record or appeal provision I have. Alternative remedy.
Show
Section
me
18.
interim order.
Interim order,
Which
41.
provision?
89, section 89. 89 to 89.
MS Bora has further submitted that the petitioner association has an alternative, an efficacious remedy in the form of appeal, provided by section 89 of the Motor Vehicles Act,
Lordship may also note this is not applicable in.
1988.
There is
I'll
no
ask
application.
if required.
Look, this provision has no application in this case, 103.
No,
Under-
89 suspension is there.
Suspension is there.
Suspension there, but under certain conditions, not in this such a condition.
If I require,
Yes, my lord, I just point out to your lordship. Otherwise, it is not possible.
heard, তাতে উপরে লিখো, heard the learned counsel for the parties also on the interim.
Lordship,
Issue notice, matter would require further examination. Issue notice, returnable on 1/3/2024 as MS Bora, Standing Council. Transport Department has appeared and accepted notice on behalf of all the respondents, no formal notice to the said respondents appears necessary. However, Learned Counsel, MS Begum, Learned Counsel for the petitioner shall furnish requisite number of extra copies of the petition along with annexes to MS Bora by tomorrow,
Lordship, I have scanned the represent copy, no need to serve the hard copy, I not required, my lord. I have scanned the represent copy and sent.
Okay, I am passing the order.
My lord.
You can refuse.
I'm helping
Yeah,
the
there you go.
petitioner.
Art also on 19 fair. Good stuff. So far as the first preliminary point raised by the petitioner, comma, as regards representation or as regards that that the regional transport authority should be represented by its chairman does not primarily appears to be sustainable for the reason that the district transport officer Kamrup Metro is the ex officio secretary,
Yes, my lord.
ex officio secretary as per the provisions contained in sub rule
60. Lordship, 6.
6
Lordship.
of rule
43, my lord. No,
41.
41.
No, not
Lordship. 60.
no. Is the secretary, appointed secretary of the Regional Transport Authority under sub rule 7 of rule 41 of the Assam
Yes.
Motor Vehicles
Rule 2000.
Rules 2006, framed in exercise of the powers conferred under various provisions of the Motor Vehicles Act 1988. Full stop. As regards the second preliminary point relating to locus of the person who has represented the petitioner association in this writ petition, comma, MS Bora has referred to various correspondences which are of dates prior to institution of the present writ petition on 3/2/2024.
Lordship, the complaint regarding the formation of the committee, Lordship. And the RTA meeting.
There is, MS Bora has drawn attention to a complaint Which
Okay,
one?
6 January 2024.
Page
No, look, the separate one.
complaint, comma, stated to have been submitted by about 58 numbers of members of the petitioner association before the chairman RTA Kamrup Metro and to the Register of Arms and Societies Assam on 6/1/2024.
And Lordship, the decision taken in the RTA meeting.
Full stop. By the said representation, comma, those members have raised an issue of formation of the new executive committee of the petitioner association in an unconstitutional manner. Full stop. On the other hand, Mr. Mohanto, learned senior counsel for the appearing for the petitioner, has placed the proceedings of the meeting, proceedings of a meeting of the Petitioner Association, held on 4/1/2024, whereby a new executive committee of the Petitioner Association has been formed with agenda number 3, go. Full stop. The locus, full stop, from the respective rival contentions
Lordship, may I
advanced by the Planetary Council for the parties on the point of locus, it appears that the same appears to be a disputed question of fact, which does not require a consideration at this stage unless the state respondents who has raised this issue can rebut the same by way of cogent materials. Full stop. Para. It is section 66. Chapter 5, Roman 5 of the Motor Vehicle Act, Motor Vehicles Act 1880, deals with control of transport vehicle, full stop, as per section 66, subsection 1 of section 66, necessity for permits, no owner of a motor vehicle shall use or permit the use of that vehicle as a transport vehicle in any public place, whether or not such vehicle is actually carrying any passengers or goods, save in accordance with the conditions of a permit granted or countersigned by a regional or state transport authority or any prescribed authority authorizing him the use of the vehicle in that place in the manner in which the vehicle is being used. Full stop. Section 72 has provided for grant of stage carriage permit. Full stop. Subsection 2 has prescribed that the regional transport authority, while granting a stage carriage permit, can attach to the permit a number of conditions mentioned therein. Full stop. By it can attach a condition in the permit to the effect that the vehicle to which the permit is granted, shall be used only in a specified area or on a specified route or routes. Full stop. It is a specific case of the petitioners that permits granted to the owners of the 200 number of city buses, who are members of the petitioner association, are on specified route with a specific validity period. Full stop. The decision to withdraw 200 number of buses with effect from WEF 1/1/2024 clearly appears to be an action amounting to suspension of those permits as the permit holders would not be able to operate the carriages owned by them in any other routes because of the impugned decision dated 28/12/2023. Full stop. Para. Nalage para. Para digo. Section 86 has provided for cancellation and suspension of permits. As per subsection, as per subsection 1 thereof, the transport authority which granted a permit may cancel the permit or may suspend the permit for such period as it thinks fit for the regions outlined therein as A, B, C, D, E, and F. Any condition fulfilled?
My lord, 86.
A, B, C, D, E.
86, 6 maybe kindly have a look.
We are into 86(1).
We are not suspending their permits, lordship,
On court is observing it amounts to suspension.
but we are not suspending their permits in my humble.
Court is observing it amounts to suspension.
And 86.
You come up with appropriate pleading.
Lordship, my lord, may I kindly have a look at
On perusal of the grounds outlined as A, B, C, D, E, and F in subsection 1 of section 86, it does not appear, prima facie, it does not appear that the respondent authorities, the ground on which the respondent authorities has stopped the permit holders from operating their stage carriage buses WF 1/1/2024 fall within the purview, fall within the ambit of either A or B or C or D or E or F. Full stop. The proviso to subsection 1 has clearly laid down that no permit shall be suspended or cancelled unless an opportunity has been given to the holder of the permit to furnish his explanation. Full stop. As no prior opportunity has been granted. Full stop. It is not disputed that full stop. It is the present the full stop. The petitioner association has asserted that no prior show cause notice was issued to any of the permit holders of 200 number of buses prior to the decision taken on 28/12/2023. Full stop. Para. As regards availability of an adequate and efficacious remedy in the form of appeal under section 89 is
And
concerned, comma,
86, sub-rule 6.
86 is 89.
89 and 86, Lordship, and sub-rule 6 also, it is reflected.
We're
89.
not deciding the repetition, madam. Is concerned, comma. It is not a rule of law that a writ petition is not maintainable if an remedy in the form of appeal is available. Full stop. It has been held by the Honorable Supreme Court of India in Whirlpool Corporation versus so-and-so, reported in 1998 SSC, and Hormon Sahania, so-and-so versus reported in so-and-so, that in even even if an appeal, alternative remedy in the form of appeal is available, comma, a writ petition is maintainable on the following grounds. One, এটা তো virus. Authority issuing the so-and-so as a whole principles of natural justice. It appears, having found that before taking an action by the impugned notice dated 28/12/2003, which amounts to suspension, no prior opportunity was provided, and the same amounts to violation of the principles of natural justice. In such view of the matter, comma, this court is of the considered view that the petitioner has made out a prima facie case for suspension of the notice dated 28/12/2023. Accordingly, comma, it is ordered that till the returnable date, comma, the operation of the notice dated 28/12/2023, whereby 200 number of city buses having valid permits have been withdrawn with effect from 1/1/2024 shall remain suspended. Full stop. As a corollary, it is further observed that this interim order shall be in respect of those stage case permits which have validity period beyond beyond what is the date today?
7, Lordship.
7/2024. If somebody has invalid permit, he is not.
Lordship.
Otherwise, also they cannot.
Lordship, may I submit one thing? They are stopping plying the vehicle in the GS road, the permit, and we are inducting the 200 electricity buses. Now from tomorrow.
Okay, MS Bora. Miss MS Bora, line standing up. MS Bora has further submitted that the respondent authorities are in consideration
My lord.
for relocation of the permit holders
my lord,
in other specified routes.
my lord.
But a final decision in that regard has not been taken yet.
Lordship may kindly directed a specified time period. Because from tomorrow, if they are also applying that, we cannot reach the
Now it
court.
is your agency. Ball
lord.
is in your court now.
Lordship,
Ball is in your court. You can take the decision within 1 day or 6 months.
my lord, from tomorrow,
Better for the city dwellers if you take the decision very early.
Lordship, we will take
From the point of
decision.
view of pollution.
My lord, from tomorrow, we cannot reach the court. It will take 6 to 7 hours from Ganeshguri to.
That is why.
Because 200 vehicles
Who has
already
stopped
inducted.
you? No, who has stopped you to
Lordship,
relocate the permit holders in some other places?
Yes, we are.
Send them to Guwahati to Haju.
My lord, they should have formulated the scheme long back and then floated it and then go ahead. Now all
Lordship
these
may kindly specify the
submissions
time
are
period.
totally irrelevant.
What?
They may.
I cannot.
Irrelevant submissions.
I cannot.
Small
will
lordship,
ignore it.
it's a.
MS Bora, I cannot
But tomorrow.
prescribe the time period.
We cannot imagine the situation in the GS road. 200 electric buses already inducted.
No, no,
And
that
the
is wrong,
other
my lord.
200.
MS Bora
80 buses to
No,
my
lordship.
information. These are all
Then tomorrow we
irrelevant
cannot
considerations.
reach
and documents placed by Mr. Mohanto and Senior Counsel for the petitioner and MS Bora and Standing Counsel, Transport Department are kept, are to be kept with the case record.
Lordship, one prayer, Lordship. Lordship, the pendency of the writ petition shall not be a bar for the respondent to take a decision immediately, Lordship.
No, my lord.
Lordship, pendency may not be a bar. That decision, Lordship may kindly observe this, word, my lord.
They are not-
Pendency of the writ petition shall not be a bar to the respondent to take a decision immediately, my lord. The date of
Pendency,
the.
it is however observed that
My lord.
It is my
Ah.
petition.
Pendency.
And they are
Yes,
not
Lordship, this is
restrained.
my prayer before. the
Lordship
Honorable
has
Court.
already observed. They can take the decision at
Lordship
any
may kindly
time.
observe deadline.
Lordship has not restrained them. This is my petition. How can they ask for relief?
it is quite reasonable.
Lordship is quite right, my lord, saying that
My
it
lord
is
may
your
kindly
agency.
observe deadline only.
Why should?
It is, however, observed. It is observed. However, it is however observed that pendency of the petition shall not be a bar for the state respondents to consider the matter of to consider modification of the permits
My lord.
of
My
the
lord,
petitioner
Lordship,
with hearing, with opportunity of hearing to the petitioners
in accordance with law.
in accordance with law.
Well,
My lord.
because what I,
Lordship, Lordship.
what,
Mr. Mohanto, sometimes it may appear,
no, no.
sometimes it may appear that your petitioners may be interested because if
No,
they
no.
take action.
No, my lord, I am not against that. What I want to place before Lordship is not restraining them. Ball is in their court. They have the authority to take. But they want the sanction from this court tomorrow that may come to my injuries. It may prejudice me. Because they may say, we got the sanction from the court to formulate a scheme which is not in accordance with law. Then
In accordance with law.
Lordship,
that is why I am saying. my lord,
Strictly in accordance with the provisions of the Motor Vehicles Act 1988.
Exactly.
And the
I have
rules framed
exercised-
thereunder.
My lord, my lord. I'm deeply obliged, my lord.
Otherwise,
MBX.
Yes,
tomorrow
yes, my
they
lord.
can say, court has given
No,
us
no,
sanction, we have done it. How can
No,
you
we
say?
are withdrawing the permit, but still they need clarification.
My lord,
Strictly in accordance with the
With law.
provisions of the motor vehicles and the rules framed thereunder.
my lord,
My lord.
who have restrained them, that is why should they?
There is
Why-
no bar for observing so,
Yes,
Mr.
my lord.
Mohanto.
Unnecessarily, this court will not observe something
No,
which
no,
will
no.
give them a handle.
This is my prayer.
That is my
Lordship,
only,
my prayer.
my lord,
Grant.
pointing
I
out to you.
feel
Lord.
that
I'm
deems it
deeply obliged,
appropriate
my
to
lord.
keep this.
I'm deeply
Lordship
obliged.
may give, but my, because otherwise something which
No,
can be
yes,
done.
there is a matter is pending
There
before
is
this
nothing.
honorable court. The
They will
respondent
use
doesn't
it
want to
to
take
their-
a decision, my lord.
That man.
I'm so deeply obliged, Lordship.
Obliging.
হরমোনস এইখানে না ওটা দিব তাতে গ্রাউন্ড কে আসছাম ডিটেল হরমোনস লাল না হয় এই করছে প্যারাগ্রাফ এইমাত্র ডিটেকশন কোনে লৈছিল ইয়াতে আছে এইখিনিকে লিখি দিম
My lord, this matter may be adjourned for the day and maybe.
On the prayer of Mr.
SR Babu.
S.R. Bovia Learned Counsel for the petition, the case is adjourned for the day. MS MD Boral and Standing Counsel,
Cooperation.
Maybe listed.
Cooperation Department is in
Maybe
attendance.
listed after
DPW.
16 to my. 16 to.
Okay, after adjourned for a week.
Deeply obliged, sir.
For admission item number 20.
Lordship, earlier the respondent who has appeared for the respondent of 4 and 5, my lord, is submitted the inability to appear, my lord, before this court. Then, my lord, case Okarat number is filed by me, my yesterday, my lord. I am appearing for the respondent number 4 and 5 for the State Bank of India, my lord.
For the State Bank of India.
And Lordship, short date may be given because the retired persons. those who-
Appears to be reasonable.
Yes, my lord. Otherwise, I have to record. my lord.
Yes, all.
Okay, but he is newly engaged now.
But my lord, affidavit. is
Everybody
filed-
will have such difficulty,
Yes.
but not this in month, Mr.
But my
Kavilda.
lord, my lord, here,
Kavilda,
the fact is already that, my lord, affidavit already filed by the earlier.
I'm giving you time.
Fine.
It will be posted in March. Will it be all right?
My lord,
March is enough time for you to prepare.
my lord.
Mr. A.
R. Tohbildar.
Tohbildar, Learned Counsel for the petitioners. B. Hazarika, Learned Counsel for the respondent number 1, 2, and 3. Third. Mr.
K das, your lordship.
A. Das.
K.
K. Das. Oh, and also Mr. H. Sharma, Learned Additional Senior Government Advocate, Assam, for the respondent number 6. Full stop. Mr. K. Das, Learned Counsel, has submitted that he has entered appearance on behalf of the respondent number 4 and 5 by filing Okalatama only yesterday. Full stop. He has further prayed that the case be listed after 2 weeks so as to enable him to obtain to complete his instructions. Full stop. List. Mr. Hazarika, Learned Counsel for respondent number 1, 2, and 3 has submitted that he has received the records of complaint case number so and so. Agora order to fill from the Office of the Banking Ombudsman. Full stop. As agreed to by the Learned Counsel for the parties, release the case on 4/3/2024. The Mr. Hazarika shall retain the records he has received.
Lordship, can it be on 5/3?
Sir,
Obliged. Obliged.
Yes.
Two analogous matters, my lord, pertaining to the analogous matter. These are two petitions of.
What is the subject?
And my lord, petition to apprise honorable court of the instructions obtained from the BTC, my lord. My learned friend will apprise today, my lord. I understand.
Has been living with his family, measuring 1 katha.
Yes, settlement of land, my lord,
Kasi Hari Singha. Akshay Kumar Sharma. Regarding settlement. Yes, no, no affidavit till date.
Insofar as my instruction is concerned, my lord, the settlement is under process, my lord. My lord, Circle Officer of Harisingha Revenue Circle has submitted the settlement proposal individual and allotment proposal of land duly first approved by Subdivisional Land Advisory Committee meeting held on 7/11/2022 under Harishinga Revenue Circle in respect of the High Court case by under reference, my lord, pursuant to this High Court direction, my lord. The process is, my lord, settlement is under process, my lord. And my lord, it's also approved by the Sub-Divisional Land Advisory Committee, my lord, in favor of the.
Yes, sir. What to do? Why should we keep this writ petition pending? Let the process
My lord.
be brought to logical conclusion
Yes, my lord.
My lord.
We don't object to that.
as expeditiously as possible,
Yes, my lord.
We don't object.
preferably within a period of
My lord, 1 month, my lord, or
3 months. Okay. Heard, Mr. There are two petitions. Two repetitions. Separate land or what?
Separate landlord.
There are two repetitions.
Yes, my lord.
Separate land. One father is same, two sons before your
No, but
lordship.
that's my lord.
One is claiming 1 katha under the same dump.
One katta is my lord.
And another one is claiming 2 kathas. It's not permissible. Only one family, one plot of land.
Yes, my lord. There are
But
two
even then,
brothers.
lordship BTC is there. Lord. I have-
my lord. Let
What
us
about-
take a decision. my lord.
What about the this first repetition and second repetition? You have received instruction in both the repetitions.
It's perhaps it appears for the board, my lord.
Let us have a look at
WPC
the,
number 5618.
let us have a look at the instruction. Can I have a look?
It is a very short.
Later, they-
দুইটা
ওই বলে কি?
দুইটা আছে।
এটা দেখেছেন দিবি তো তারপর মতো দেখানো
Two repetitions are there.
Both the repetitions. When would observe that the process should be brought to a conclusion
My lord.
in accordance with law.
Yes, my lord.
But this court will make it clear that it has not made any comment as regards the merits of the respective claims. Yes, Mr. Sharma?
মানে if a time limit is possible, my lord, by the committee through disposal of the petitions.
Heard Mr. J.P. Sharma, learned counsel for the petitioners. In both the petitions. Also heard. MSN Bordole, Standing Council, Revenue within Vegas Settlement Department for the respond number 1. Mr. S.R. Rabha,
2, 4, and 5.
BTC for the respond number 2, 4, and 5. And Mr. H. Sharma, learned additional senior government advocate Assam for the respond number 4.
Members,
As the
Land advisory.
relief sought for in the two repetitions is same. Colon, semicolon. The issues involved and the issues involved in the two repetitions are same. And the respondents are same. Internal ID. The both the petitions are taken up for disposal at the admission stage as agreed to by the Learned Council for the parties. Full stop. It is submitted that it is further submitted that by Mr. Abha, Standing Council BTC, that the instructions he has received will be sufficient for the disposal of both the petitions. Full stop. The same father. Oxoy. Okay. The first petition was originally filed by one Diju Kumar Sharma. The writ petition, sorry. Writ petition, WBC number 5618/2022 was originally filed by one Diju Kumar Sharma, who has been substituted by his son, by his wife. Later. Full stop. The writ petition, WBC number 5581/2022 is filed by one Sri Navakumar Sharma. Full stop. Late Diju Kumar Sharma and Sri Navakumar Sharma were sons of one late Akshay Kumar Sharma. Full stop. In the writ petition, WBC number 5618/2022, the petitioner has claimed that late Akshay Kumar Sharma is in possession of government caste land since a long period of time. And the area of such land is one katha comprised in Dag number 1563 and Tozi Patta number 8, situate at Tongla town, Moja Dakua, Horisinga Revenue Circle, District Udalguri BTAD, Sam, within bracket, the subject plot number 1 or short. In the restriction, next repeat koribo since long, measuring 2 kathas. Dag number same. Oji Patta number same subject of number 2. It is a common case of the petitioners, two petitioners, is that in view of their long possession of the subject plots, they are entitled to be granted settlement. Full stop. And for that purpose, they preferred application for such settlement. Full stop. On the basis of their respective applications, the respondent authorities processed the matter for settlement. Full stop. After finding the the petitioners have stated that the circle officer Horishinga Revenue Circle after processing respective proposals, respective proposals for settlement. After কি করলো? Preparing. I have forwarded those proposals along with necessary reports, to the member secretary, Land Advisory Board for further consideration. Full stop. As despite submission of those proposals as far back as in the year 2008, the respondent authorities have not brought the process to any conclusion, the petitioners are before this court by the two writ petitions seeking inter alia, seeking a direction to the respondent authorities to process and pass necessary orders as regards grant of patta stroke settlement of the subject plots in respect of the subject plots. Mr. Rava, learned standing counsel BTC.
A period may prescribe, if a period is there for the compliance, but if a period is prescribed, if your lordship please to prescribe a period, within such period that they should pass the decision.
I am proposing it. I have indicated. I have indicated already. You have not heard. Mr. Rava, standing counsel, BTC, who was asked to obtain instruction in the matter, has submitted that he has received instructions in respect of both the petitions. Provide communication from the Land Revenue and DM Department, BTC, provide communication bearing number so and so, dated 16 October 2023. Full stop. On the basis of by placing a copy of the said communication dated 16 to 2023, Mr. Rava has submitted that the settlements, stroke allotments, within bracket, individual proposals of the in respect of the petitioners is under process in the Land Revenue Department, BTC, and necessary action will be taken in this regard. Full stop. Mr. Sharma, Land Counsel, appearing for a petition, has submitted that the proposal for settlement stroke allotment were sent, since proposals were sent as far back as in the year 2008, the respondent authorities should bring the entire process to a conclusion as expeditiously as in an expeditious manner. Full stop. On perusal, in view of the submission made by Mr. Abal and Standing Council BTC that the settlement stroke allotment proposals in respect to the petitioners as regards the subject plots, comma, mentioned here in above, comma, are under consideration at the end of the Land Revenue Department, comma, BTC, and the necessary and the decision in that connection will be taken with expedition, comma, this court is of the considered view that instead of keeping this petitions pending, the same can be disposed of with a direction to bring the proposals regarding settlement stroke allotment of the subject plots in favor of the relating to the petitioners to a logical conclusion with utmost expedition. Considering the fact that the proposals for settlement stroke allotment are pending since 2008, comma, it is observed that the respondent authorities shall bring the process to a conclusion with utmost expedition, comma, but not later than an outer limit of 3 months from today. Full stop. It is accordingly ordered. Okay, it is, however, made clear that this court has not made any observation as regards the merits of the claims of the petitioner for settlement or allotment of the subject plots. So it is made clear that the consideration for allotment or settlement of the subject plots shall be made by the respondent authorities in strict observance, strict compliance of the extant rules and regulations. This order disposes of both the petitions. No cost.
Item 23.
Past earlier shall continue. Yes.
Herein, my lord, the affidavit of the respondents is awaited.
Oh. Yes, Mr. Sharma.
We have received the instructions wherefrom it transpires that the status of the writ petition and the so-called predecessor, so and so, the land under their position are that of the encroachers. The various DAG numbers mentioned against the land of the petitioners are incorrect and some of the DAGs are not even existing as per official records.
Bring that on record.
I have an affidavit, Lordship, we have to.
As
Otherwise, certain disputed question of facts are also. Lordship, we will.
That after exchange of pleading only.
Lordship, it can be. Lordship.
We can arrive at, yes, it is disputed question.
Lordship.
Heard Mr. S. They learned counsel for the petitioners.
Interim as maybe.
Yes.
Lordship, 4 weeks, Lordship will file.
MS N. Bordoloi, Standing Council Revenue Department 1. H. Sharma, learned traditional senior government advocate for the respondent number 224.
Lordship.
Post of Mr. Sharma has submitted that necessary instructions have been received and has, does, prayed for 4 weeks' time to enable him to file counter affidavit on behalf of the respondent number 2 to 4. So, the prayer is allowed, release the case after 4 weeks. The interim order passed earlier shall continue.
Your Lordship, may I pray for a fixed date?
Fixed date.
Any date as per your
Oh,
Lordship,
fixed date.
after 4 weeks, any
11-3.
Lordship.
Much obliged.
Item 24.
May I please your lordship? Lordship, we have received affidavit in opposition this morning.
We have not also received. Yes, tell me.
Lordship,
How much time?
3 weeks.
3 weeks. To file reply?
Yes, lordship.
Reply. Third MS
N. Chaudhary.
and Chaudhary. Learned counsel for the petition. NMS
H. Das,
H. Das. Learned counsel for the respondents.
respondents.
Post of MS Chaudhary has submitted that a copy of the affidavit in opposition of the respondents has been received today or yesterday,
This morning.
Today.
This morning.
and the petitioner needs 3 weeks time to go through the same and to file an affidavit in reply, if so advised. A prayer made on behalf of the petitioner is allowed. Release the case after 3 weeks.
Highly your lordship.
Item 25.
May I please your lordship? Lordship, this matter pertains to a demarcation of land, my lord.
Demarcation?
Yes, ma'am. So far, my lord, here 2 writ petitioners are before your lordship, my lord. And so far, writ petitioner number 1, my lord, writ petitioner 1 and 2, my lord, they are a joint title holder, possessor of a plot of land measuring 1 katha, my lord, 7.4 lechas in this over the said document. So far, writ petition number 2, my lord, he has purchased by virtue of a sale deed a plot of land measuring 2 katha 15 lechas, my lord, over the said duct, and they have been jointly possessing the said land, my lord. And so far as this land is concerned, my lord, since the said land is lying without proper boundary walls, my lord, taking advantage of the situations, my lord, the neighbors from the adjacent ducts are trying to encroach the land. Basing on that, my lord, we preferred a petition before the respondent number 3, that is the circle officer, my lord, of Helm Circle, my lord, for demarcating as well as identification and measurement of the land, my lord. And since then, my lord, this petition has been pending.
Yes.
Lordship, in this case also, Lordship, we have received the instructions whereby it reveals that the most probably, Lordship, we have to bring it back. We have a record affidavit, Lordship.
What does it say?
The patta holder of the name late Khudiram Sharma for the said plot of land under his name is not recorded.
Lord,
Khudiram.
Yes, Lord.
that is the predecessor in interest of the
Under Helm, as per records, there is no patta holder of the name of late Khudiram Sharma for the said plot of land under Helm Revenue.
Where is your patta?
Patta, my lord, I have annexed the copy of the Jamabandi, my lord.
Jamabandi does not mean title.
My lord, we have mutation. The mutation, the order of
Mutation is only for the purpose of revenue.
revenue, my lord.
Where is your title?
Title, my lord, we are possessing the land.
So
But
you are
there is-
possessing from Khudiram.
Khudiram, my
What
lord.
is the title of Khudiram?
Khudiram, my lord, here by virtue of being class 1 legal heir of Khudiram, my lord.
Okay, you are class 1 here, admitted,
Yes, yes.
taken.
Yes, my lord.
What about Khudiram?
So far as
They are
Khudiram,
saying
my lord,
Khudiram has no title. No
my lord,
patta.
my lord, but in the said prima facie, my lord, if we upon perusal of the Jamamandi, if my lord comes to the Jamamandi part, my lord, here, my lord, on virtue of being class 1 legal heir only, we have been accorded mutation, my lord. And mutation was being granted way back in 1996, my lord,
Mutation is for the purpose, what purpose?
for the purpose of
For the
assessing
purpose of
tax
accessing the revenue.
revenue, my lord, estate, in respect of our estate. But we were conferred mutation, my lord.
Mutation can be by way of purchase.
Yes, yes.
By way of
Yes.
Inheritance.
Inheritance, but
Right.
yes, my lord.
What about Khudiram's patta? Title?
My lord, for that, my lord, if lordship gives me some time, for that, my lord, I will take certain instruction on that. But in the due course, if they want to bring it on record by way of affidavit, my lord, they can.
They may bring also, but question is 1 minute.
Only as regard to
1 minute,
demarcation.
1 minute, 1 minute. This second petitioner, he says that he purchased the plot of land from.
Yes.
Ah,
Yes, one, here, my lord, 322, my lord. The petitioners was regard in respect of that
High
number
Court has been relegated to a position of demarcation.
320.
Yes, of demarcation, Mr.
4 katha and 1 left, 4 katha, 1 lechas of land, my lord.
What the circle officer does? Who is there? Any case has been registered?
Petition was accepted, my lord, but no such
The
further
a
proceedings.
complaint petition was received from one so and so, who is a pattadar of the adjacent tag number so and so of the concerned plot of land. And the said demarcation because of that could not be done.
Mr.
Pidas, my lord.
Pidas for the petitions. And Borderline Revenue 1, H. Sharma, so and so, 2 and 3. Mr. Sharma has submitted that he has received instructions. And a counterfeit will be filed within 3 weeks' time. Post up. He has further submitted that from the instructions he has received, it transpires that Khudiram Sharma did not have any title in respect of which the petitioner are seeking mutation. Post up. The counsel for the petitioner shall complete his instructions in the matter. In the meantime, place the case after 3 weeks for filing of counter by the state respondents.
A fixed date may be given.
We are not very interested in demarcation process. We are not interested to become circle officer.
Item number 26.
My lord, this is the case where the society's cooperative society license have been cancelled in an illegal manner. My lord, may kindly see that cooperative society license was cancelled, page 17, kindly see.
Page
17. On particular day, the superintendent visited the one officer of the department visited the premises and found some anomalies in the accounts and stocks. Then the license was cancelled.
TPDS will have system the intermediate TPDS 2015. TPDS will have 2015. This is not the cancellation order, it is a so-called notice. If you have read properly page 18,
Here, my lord, the shop was decked.
that is different matter. It is a so-called notice. Please read 18.
Yes. No, however, that is, from that day, we are not getting anything from government.
That is different matter.
Now-
It is a so-called notice.
Yes, now lordship kindly see, page 16, my lord. I am the secretary. And I was appointed on 24/8/2021. But I got charge of secretary on 29/10/21. Page 21 kindly see now, page 21. Earlier secretary was Dilwar Hussain Borvia. And I got the charge only on 29/10/21. That is on the day when instruction was made, I was not the secretary.
Mr. Mahmood,
Hello.
please explain me one condition, one situation. Deputy Commissioner is the head of the district.
Yes.
How he will come to know that Mr. Z.M. Tuspikwetur Ahmed Loskar is the secretary of the cooperative society.
Yes.
He goes on visiting every cooperative society,
Yes.
Deputy Commissioner.
Yes.
How come he knows on 10/9/2021 that Mr. Tuspikwetur Ahmed Loskar
Yes.
is the secretary of the society? If somebody does not inform him,
My lord, kindly see page 29. I have informed them, that is page 29, to the Assistant Registrar of Cooperative Societies, Kachar.
come to page 17, please satisfy me. Last paragraph.
Yes.
How come your name is reflected in the show cause notice dated 10/9/2021 issued by the Superintendent Food and Civil Supplies and Consumer Affairs? How come? These are internal documents of cooperative societies.
No, this is not.
These are
internal.
Rangpur Cooperative Society, very private
No,
body.
no, it is received by the Superintendent Food and Civil Supply. Page 30, kindly see, we have informed. He is the authority, Superintendent Food and Civil Supplies, Consumer Affairs, page 30, kindly see left side. He received it.
Okay, we'll see that.
Yes. Now, lordship,
We'll see that. Let me have a look.
Oh, this is your letter.
I informed the officer, and officer knows this. Thereafter, my lord, I prayed, that is page 30, I prayed that as I was not the secretary at that time, or at least I did not get the charge. So I should be given the license so that the materials can be lifted and staffs may be paid. But they did not do anything. Then, my lord, I approached the Honorable High Court. And High Court passed order that operative portion of the order may be seen page 34.
What is the representation dated 13/9/2021?
June 9, 2021. Page 19.
Page 19. Yes.
Then, my lord, I filed the representation again. Again, that kindly give me the license back, otherwise staffs are suffering, consumers are suffering.
Petition was disposed of perhaps.
No, that is not.
5603/2021.
No, that was ultimately after giving detailed show cause reply. License was cancelled, page 44. Earlier it was suspended, now it is cancelled, page 44.
Let us page 44.
Yes.
This was 28.
28, 10, 22. Page
Let us read the disposal order first. Because it was prior to that. Page 37.
Is High Court's order.
It was prior to.
Yes, yes.
Prior to.
Yes. Page 39, operative person, para 7.
I will read. Yes, page 39. Para 6.
Yes.
Read.
We are unable to accept the said contention as much the allegation in the show cause notice is against the cooperative society as a whole, and whoever is holding the post of secretary of the cooperative society under the law would be required to reply to the show cause notice. As it is only a show cause notice to the society as to why the license should not be cancelled, we are of the view that no interference is required against the order in a writ proceeding, and the secretary of the cooperative society may submit his show cause reply to the show cause notice that is so and so.
So it was disposed of with a direction to pass a speaking order.
Thereafter, then we submitted the reply of the
Very
show
good.
cause. Then this,
Very
that may be seen, my lord, page 42.
Page
42, annexure 10.
So what is the main ground?
Main first ground is secretary. On that particular day, I was not the secretary, outgoing secretary.
That is different matter. That does not have any relevance.
Thereafter, Lordship, I
You are-
submitted detailed reply.
The court has already observed in para 6.
Yes. Observe.
Whoever is the secretary does not have any significance. It is the allegation which are against the society,
Yes.
which are of relevance. Tell me, what is the reply in the show cause
Yes, that is.
in 42?
Yes.
Specifically to defend the case of the society, not regarding the employee secretary.
Secretary represents the
That is
society.
different thing, society.
Yes,
You
however.
are not in charge, that is a different matter.
Yes. Yes, now, my lord, reply was given.
What are the grounds? Because, see, Mr. Mahmood, this show cause notice has some allegations.
Yes.
Page 17.
Yes.
Which are regarding quintals, kgs, rice, atta and all.
Yes.
We don't decide those.
Yes.
These are factual allegations.
Yes.
Right? Which are required to be decided by the competent
Authority.
fact-finding
Yes.
authority.
Yes.
Now, what did you reply in your reply to show cause? This much attas were missing, this much quintals of rice were missing, this, that were missing. Secretary does not have any significance. Am I clear?
Well, I understand that. But
please
even
show
then,
me- show me.
everything is pertaining to the society.
Show me in the reply to show cause.
Reply, long reply, madam.
How you have dealt with these attas and rices,
Oh,
quintals and kgs.
Let me clarify the question, my lord. When I submitted reply, then authority were not satisfied. They cancelled the license. There is a provision under section 9 that appeal should be filed before the deputy commissioner. Then I filed the appeal before the deputy commissioner. The deputy commissioner is keeping silent since long. That is the grievance that the deputy commissioner is doing nothing.
He can examine these quintals and attas and rices and
No, law
kgs.
law
We don't
permits this,
decide.
but I am saying
If
about the
appeal
law.
is pending,
Yes, appeal is pending.
then that appeal.
And they are not taking any decision. And
If that is the case, because we will not decide about quintals and
that,
kgs, attas, moidas.
now kindly see page 46, well. 46.
46.
Yes.
Appeal. This is the appeal.
Appeal.
Before
Before the
Deputy-
deputy commissioner?
he is the appellate authority.
Yes.
Under the APD order.
Yes. But he is doing nothing, and it is filed lordship on 14/11/22, can you see? So they have some total negligency. That was their
I
own.
think there is an affidavit. Is it so?
Yes.
They have filed affidavit. When
What does it say?
In affidavit, my lord, they
Are
have.
they speaking about the appeal?
No, that was not there.
Huh?
That was not there. And appeal, one thing, another thing, my lord. There is a police case. Honorable High Court granted me anticipatory bail. Then in the long run, charge sheet was filed, and the London magistrate who called the parties. Kindly see now page 62. So I have been discharged against all the charges. Page 62, kindly see.
Discharge does not mean acquittal.
No, acquittal in their presence, my lord.
No, what is their stand in the affidavit?
And for a moment, kindly see page 62, my lord. Very
Page
short
62
order.
of what?
Page 62.
Page 62.
Yes. The informant, Dipens Kumar Sharma has appeared before this court with a petition number so-and-so, dated so-and-so, wherein he has stated.
Proceed, doesn't want to proceed.
Yes, in writing, he does not want to proceed the case. He has no objection against the final report which has been submitted by the IO and paid for, for accepting the same.
Okay, final report.
So, my final report, yes.
Understood.
Now, Lordship, kindly see, on the particular day, I was not the secretary. I submitted appeal.
Secretary, you have submitted the will be specifically licenses issued.
In the name of secretary, not in the name of society. So, secretary,
You proceed, please.
secretary,
You proceed, you please.
the secretary so and so society.
You proceed, please. Let us come to the affidavit of the state.
They have filed affidavit, that is, DC has filed. Their affidavit, page 67, kindly see. They have admitted appeal is pending before me.
What they are saying in paragraph 4 of the affidavit of opposition, please read.
Para 4. That with regard to the amendments made in para 3 and 4, the writ petition, the Department Magistrate said that the Assistant Registrar of Cooperative Societies, Silchar, wrote a letter to the Deputy Commissioner Kassan informing about appointment of J.M. Iftikhar Ahmed Lashkar as Secretary of Rangpur Cooperative Society Limited, and accordingly he joined on 31/8/21 and lifted all symmetric rights including NFSA so-and-so from FCI Silchar. It is fact that says articles so-and-so quintals of rice were given Jimma to Sri J.M. Iftikhar Lashkar, Ahmed Lashkar, Secretary of Rangpur Cooperative Society Limited. On vacating the Jimma from J.M. to Speaker Ahmed Lashkar, Secretary of so-and-so, the articles were handed over to Secretary Messrs. Gorakhpur Sonapur Cooperative Society Limited. This quantity is found only so-and-so quintals instead of so-and-so 144 quintals. Thus, total shortage quantity of rice raised 474.11 is mentioned here that on the day of seizing total stock of rice as per display board was 1492 quintals and the inspecting staff found existing physical stock only 1075 quintals. On the day that is on 7/9/21, 36732 quintals of rice arrived at CPS at around 5 p.m. from FCI Silchar, number so-and-so, which was not reflected in display board. It is also stated that discrepancy in quintals occurred during the Jimma period and under the custody of Sri J.M. Tasfikar Ahmed Lashkar, Secretary, Rangpur Cooperative Society.
According to you, you were handed over the charge on
Yes.
which date? Yeah, as per your previous submission, 29/10/2021.
Yes.
On 7/9/2021,
No, this is.
You took Jimma.
Record, but yes.
Oh, you took Jimma as the secretary of the society from the government authorities
Yes.
by signing the Jimmanama. And during Jimma period, also some anomalies occurred. Did you reply to this?
All things are replied to it, and
let us see.
every point has been discussed by them in my reply. And now what is said by the.
What did
Deputy
you say
Commissioner-
about this Jimmanama?
Kindly see page 81 of my affidavit in reply.
Paragraph 4. Reply to paragraph 4. Silent. Reply to paragraph 4. There is nothing as regards Jimmanama.
No, I have taken Jimma, that is true. There is no difference.
No difference.
No, I have taken Jimma on the, as the officer handed out Jimma to me. Thereafter, it was lifted to another
So
society.
that means you have acted illegally.
No,
You have acted illegally.
Jimma.
If your charge was not handed over till 29/10/2021.
Yes.
How can you go to the government and represent yourself?
No.
That please give me Jimma.
No, Malik. I am submitting the picture. On that day, officer came. All the members of the society were present. There were some anomalies in the godown stocks. So those were seized by officer and said that you are the present secretary appointed. So you take the Jimma. Accordingly, I took the Jimma. But I did
Quite
not get.
unbelievable story.
Lordship should not.
Quite unbelievable.
Believe me.
Anyway, please proceed.
Kindly see page 81.
In page 69, which is your signature?
Page 81, kindly see for a moment.
Page 69, please come to
69.
page 69. Which is your signature?
Yes, 69.
Which is your signature?
Perhaps at the bottom right side. It is not exactly written.
Bottom two signature appearing, the upper
No.
one or lower one?
Here, signature of Jimmadar. Signature of Jimmadar. Here are two signature. It is illegible, short signature. But it is the duty of the officer. He should say that you put your full signature. So that, my lord, I cannot say anything
We
at
cannot
this.
assert in which one is correct, right? Your version or their version?
So it is, no, their version is not correct because.
No, Mister, we are in read. We do not decide.
No, that is
all
why,
the
my lord.
disputed facts.
That is why, my lord, I am submitting. Appeal is pending.
That is different.
Appeal is pending, but they are not passing any order. They have also admitted in their.
Where they have stated about appeal?
Appeal, yes. Page 67.
67.
Yes. Para 9.
This is an Assam APD order from some.
Page 67 of this is affidavit.
APD order 29 1B. The impugn order was passed by whom?
By, that is Superintendent
Superintendent of Civil.
Food and Civil Supply.
Yes, Mr. Goswami.
Yes.
Appeal is pending.
Apart from all these things, my lord, this case is not maintainable before this honorable court. because he was appointed by the board of directors. Nowhere stated, he has stated in the writ petition that he has been authorized to represent the cooperative society. All along, he is submitting before Lordship, my lord. He is no way connected with the misdeeds, my lord, with the illegality. But the illegality committed by another person of the society, that has not been ruled out, my lord. So in one hand, he is saying, my lord.
He has come with this petition that it is the secretary.
Yes.
Who is given the license.
As if, my lord, in his personal, my lord, name, it was issued, my lord. These certificate,
He feels that.
Yes, my lord. The case is not at all, yes, the appeal is pending before the deputy commissioner. Deputy commissioner will decide. That is a
Let them decide.
different
We'll
aspect
not
of that. But
enter
my
into-
respectful submission is this case is not at all maintainable because he has come before this honorable court against his personal grievance, not against the my lord society.
No, one part he has got the relief. He has been discharged or whatever.
Yes, that is different, my lord. But so far society,
Case is concerned.
so far accusation against the society, my lord, that part he has not denied, my lord. He said, my lord, his predecessor has committed this illegality. All along, he is submitting before lordship, my lord.
There is a prayer for to dispose of the appeal. Why should we enter into all these merits?
My lord,
Appeal is pending.
my
But
learned friend is-
Those submissions are not required from both the sides.
two things, my lord.
Because my lord,
Society is also before you.
because my lord,
Society is also before you.
my
my
lord,
learned friend has not seen that.
board of directors
No, no, no.
has not taken
My
up the
learned friend
matter.
has not seen that. Society
lord,
is also before you.
My lord, only except giving the name, my lord, of the petitioner number 1, nothing is there, my lord. Except that, nothing is there.
Everything
No
is there.
statement
I
is
will say
there.
everything is there.
My lord, even my lord, there is no resolution on the part of the board of directors. And board of directors has not taken up the matter appropriately. Appeal is pending, his case is there, my lord, that this will deal with.
And lordship is
But,
regarding license, kindly see page 18.
এক মিনিট, just a minute, আপুনি ক'লে মই কৈ ল'ব দিয়ক।
Vote এটা কোৱা কৈছে যে license to secretary. Kindly see page 18.
License to secretary, my lord,
Yes.
not the petitioner now, in the name of the petitioner number 2, by name, my lord. It was issued in favor of the secretary of the society,
The statutory appeal is within time.
my lord. But that
And
part, I will not
there-
say anything,
There is a mandate.
my lord. But so far, my lord, against the cancellation, my lord, this
We will not
application is
enter into factual.
My lord.
Mr.
Yes.
Tofeeqar or
Yes.
Mr. Dilwar was the secretary.
Yes,
All this.
but his case is also in the present writ petition. Only his grievance is only against him, my lord.
Let the deputy commissioner decide the appeal
Yes,
within
that
a
part-
specified time. period.
Yes, yes, yes. But
In
one
terms
thing,
of-
my lord, I am giving, come on, lordship has
uh,
raised the question.
uh,
And that I am replying, the
no.
page 18 can listen, page 18.
We will not observe anything. We'll simply.
No, no, that
appeal
is not.
pending.
License is issued in
But,
the name of secretary. I say, dear lordship, express some view. That is why I am showing, page 18 can be top. Therefore, the license issued under APDA order 1982 in favor of the secretary.
Secretary, you are secretary.
Secretary,
I think-
Mr. Mahmood.
Secretary.
Mr. Mahmood,
Well,
there is some difference between the secretary of the society
yes,
and between GM to Speaker Ahmed Loskar.
definitely.
There is a difference.
Yeah, definitely, that is true. Whoever may be secretary, license is
And
issued.
all along he is
So
It
I am
is-
the secretary, so I,
It is in the name of the secretary,
secretary.
so and so society.
Yes.
You step into the shoes of secretary.
and he has been
You do
appointed by
not-
the board of directors.
You do not become the shoe. You step into the shoes of the secretary.
That is right.
right.
I am present
We are
secretary, so I
not
so I am
into,
claiming.
Mr. We are not into it. I think appellate authority has the mandate also
Yes.
that no order which adversely affects any person shall be passed under this clause
Yes.
unless such person has been given a reasonable opportunity of being heard.
Yes.
So the society as well as the petitioner,
So far,
let
person,
him have the satisfaction.
yes, no, with that, with respect to that, my lord, I have no objection because affidavit also says so. But what he has stated, my lord, all
We'll
along
not go
before
in.
this honorable
So
court,
we'll not go into that.
my lord.
These are disputes. No, I must.
Because, my lord, he's only personal grievance. He's not no way connected with the
There
illegal.
should
So
be-
for personal grievance is concerned, that has been mitigated with his discharge.
My lord.
Criminal offense, he has got the
as
relief.
if, my lord,
Now, as a appointed secretary of the society,
my lord.
he is still aggrieved.
My lord,
Yes.
but all
Let
along
him
he's,
have the satisfaction.
yes, that is there. But all along he's blaming the predecessor, my lord, of the same society.
I am not.
Blame
documents are sent.
allow him to blame the previous secretary before the appellate authority.
But my lord, my last submission is this. Appeal is pending before the deputy commissioner since 14/11/22. Till today, he has not disposed of.
And Mr.
There should be passed.
Mr. Goswami,
My lord.
I have seen one more.
Right.
While glancing. Come to your affidavit.
Right.
Paragraph 9. While glancing, I took note of it. Paragraph 9.
Yes. I've seen this
This cannot be.
by the deputy commissioner.
It must be by the deputy commissioner.
As if deputy commissioner, I think deputy commissioner,
He cannot
Right.
delegate.
Right.
Hearing. One will hear, one will pass
I
the
think,
order. That cannot be a situation.
yes, sir.
He should hear.
Yes, he who hears, he must decide.
He who hears must decide.
And that also within time, some reasonable
But
time.
only thing, my
But
lord,
more
whether
than one, I think 22.
difficult to, my lord, sir.
More than 1 year, my lord. Appeal is pending. So lordship may pass some observation.
Pass our observation, also, Lord,
No, we will observe.
my lord. And my submission
What
may
time
also-
is the reasonable time period? Otherwise, it.
No, it is abnormal delay, my lord, on the part of the officer.
So and so. Any time period is already laid down.
Lordship may fix anything.
Mr. Amir Mahmood. Learned counsel for the petitioner and Mr. B. Goswami learned additional petitioners and Mr. B. Goswami learned additional advocate general Assam assisted by Mr. P. Kakoti,
And
learned
for
counsel
property, he is also there, my lord.
and Mr. R. B. Goswami for all the respondents. Posted. The petition number 1 is a cooperative society registered under the provisions of the Assam Cooperative Societies Act 2007. And the petitioner number 2 has stated that he is the secretary, appointed secretary of the petition number 1 society. Full stop. Perhaps in a writ petition, case of the petition society is not defended.
Yes. Nothing is there, man. Except his personal grievance. As a whole, against the society, nothing has stated.
By an order dated 10/9/2021. Comma. The respondent number four. So the petitioner number 1 society was granted an wholesaler license
Yes.
Wholesaler license.
Wholesale license.
Wholesaler license. A license under the provisions of the Assam Public Distribution of Articles Order 1982, APD order. Full stop. By an order dated 10/9/2021, comma, passed by the respondent number 4, comma. The sub-wholesale license. The license within bracket sub-wholesale issued in favor of the petition number 1 society under the APDA order 1982 in favor of its secretary was placed under suspension with immediate effect, alleging gross violation of the provisions of law mentioned therein. Full stop. By the said order, comma, the secretary of the petition number 1 society was asked to show cause as to why the license issued in favor of the society, in favor of the secretary of the petition number 1 society should not be cancelled. Full stop. The noticee was thereby asked to show cause in writing within a period of 7 days from the date of receipt of the order dated 10/9/2021. Full stop. The petitioner must have projected that a reply to the said show cause notice was duly submitted. Full stop. When when despite submission of the reply to the show cause notice, comma, the matter of suspension of the license of the petition number 1 society was not brought to any conclusion. The petitioners had preferred a writ petition, WPC number 5603/2021. Full stop. The said writ petition was disposed of by an order dated 31/8/2022. Directing the respondent number 4 to pass a region order after following the due procedure of law within a period of 2 months from the date of receipt of a certified copy of the said order. Full stop. Pursuant thereto, comma, the respondent number 4 had passed an order on 28/10/2022, whereby finding the allegations brought against the petition number 1 society to be true, allegedly finding, comma, cancel the sub-wholesale license of the petitioner number 1 society issued in the name of its secretary in exercise of powers conferred under clause 15(2) of the APD order 1982. Aggrieved thereby, comma, the petitioners had preferred an appeal before the Deputy Commissioner Tasar Assam on 14/11/2022. Full stop. Seeking the instant writ petition was filed on 21/7/2023. Seeking a number of directions, including a direction to the Deputy Commissioner Kachar Silsor within bracket. The response number 3 to dispose of the appeal pending before him. Full stop. The state respondents I contribute on behalf of the respondent number 3 and the respondent number 4. Has been filed on 29/2023, stating inter alia that the appeal submitted on behalf of the petitioners was received on 14/11/2022. Full stop. It has been further averred that a hearing was undertaken by the Executive Magistrate Kachar on 3/3/2023 and thereafter, the appeal is under process at the level of the Executive Magistrate. Full stop. After hearing the learned counsel for the parties at some length, and upon perusal of the materials brought on record by the learned counsel for the parties, by the parties through their pleadings, it transpires that a determination of number of disputed questions of fact would fall for consideration. Full stop. And for determination of such disputed questions of fact, a proceeding appears to be not an appropriate remedy. Full stop. Be that as it may. Full stop. The IPTR orders 1982 frame in exercise of powers under Section 3 of the Essential Commodities Act has provided for an appeal, in section. It is called section or order 29. Full stop. For any reference, the provisions of order 29 are reproduced herein below in its entirety. Full stop. As the state, as the respondent number 3 and the respondent number 4 have admitted that the appeal preferred by the petitioner was presented on 14/11/2022. The same is found, the appeal is found to be in compliance of clause 2 of order 29, which requires to prefer an appeal within a period of 30 days from the date of receipt of the order appealed. Full stop. As per section or order 29 within bracket 1 within bracket B, in any person agreed by an order made by an officer under the said order may if the order is made by any officer lower in rank, then the deputy commissioner, the appeal will lie to the deputy commissioner. Full stop. Since the appeal is pending before the deputy commissioner, jurisdictional deputy commissioner as the appellate authority since 14/11/2022. This court is of the considered view that the appellate authority shall proceed to consider the appeal in an expeditious manner with utmost expedition. Full stop. As clause 3 of order 29 has provided that such person who is likely to be adversely affected, should be provided a reasonable opportunity of being heard, the appellate authority should provide reasonable opportunities of being heard to all the stakeholders, including the petitioners herein, who are likely to be adversely affected if the order appeal against is likely to be affirmed. Full stop. It is settled position of law that one who hears must decide. In such view of the matter, the appeal preferred by the petitioners should be heard and disposed of by the appellate authority under Order 29(1)B of the APDA Order 1982. Full stop. Since the matter involves cancellation of sub-hold license of the petition number 1 society, it is further observed that the appeal presently pending before the appellate authority should be disposed with utmost expedition, but not later than, but within an outer limit of 45 days from the date of receipt of a certified copy of this order. It is further observed that this court has not observed anything as regards the respective claims of the parties, merits of the respective claims of the parties, and the appellate authority shall decide all the questions in accordance with merits and as per law.
My lord, highly obliged. But one thing, my lord, my learned friend repeatedly was saying that society interest is not mentioned. Kindly see para 5.
We have not
What is the?
we have not recorded any of his such submission.
No.
Whether there is any resolution of the board of directors, any resolution?
What you say?
We have not observed anything. You come with all these allegations after 45 days.
Very much we are satisfied. But thing is this, I have also mentioned
You will
about
be given all the opportunities I have said.
Yes, yes. No, he has not read, but vehemently arguing.
His statement he has not, he himself has not.
Okay. Yes.
27, 29.
We have disposed of the matter, no further argument.
Lordship, in item 27, 28, 29, in 28 and 29.
Because of your arguments, Mr. Outside the dais, we are not hearing the learned counsels for the parties.
Lordship, in item 20.
Please go outside the arena.
In item 28 and 29, we already filed affidavit. In 27, I have received.
In
Parawai's-
item?
28 and 29.
These are GST matters.
GST matters.
27, 28, 29.
27, Lordship, I have received Parawai's comments. Within 10 days, I will file my affidavit, Lordship. And in 28, 29, we have already filed our affidavit.
In these cases.
10 days time may be allowed, Lordship, for 27.
Your name, madam?
H. Jane.
H. Jane. Heard MS H. Jane, learned counsel for the petitioner. And Mr. S.C. Kal and standing counsel GST for the respondents. Any other respondents?
Union of India is there.
Also heard, Mr. Nobody. You are CGC.
I was in the 47 item. My senior is there.
Okay. Mr. S.C. Kal and standing counsel GST for the item number
27, 28, 29.
27, 28, 29.
Not.
Then where are you, Mr. Gogoi?
I was in 27. 27 is with me, Lordship. He's a junior counsel.
Along with
Yes.
Mr. Dr. B.N. Gogoi, Lion Standing Counsel GST for the respondents. Mr. Kal has submitted that in 27 and 28,
28 and 29.
28 and 29.
Already filed.
The respondent GST authorities have already filed their counter affidavits. Insofar as regards filing of counter affidavit in I-27, Mr. Kal has prayed for and is granted, has prayed for and is granted 2 weeks time to file counter affidavit on behalf of the respondent GST authorities.
Much okay.
Place the cases after 2 weeks or a date to be fixed by the office. The interim order,
Sure.
if any, past earlier shall continue till the next date.
Much.
Item number 30.
Wait, Your Lordship. In this case, Your Lordship.
Yes, mister, you are always
At the last.
young for 15. That
Yes, Your Lordship. Completely illegal, Your Lordship, without any valid reason.
is difficult. Hey, kumani commercial diyo karo. Monday diyo. Monday. We'll try. Whenever
Your Lordship may dispose of the deputy commissioner shall take a call, Your Lordship.
Monday.
May I give your Lordship? I have the instruction that social justice is a necessary party.
Huh?
Social justice and empowerment department is a necessary party, your Lordship. So.
If Mr. Goswami appears, it is okay.
Yes, sir.
If Mr. Goswami appears, we will see on merit.
Yes.
If it is required, we will implement. Okay? MH Loskar, counsel for the petition. Yeah, can I reflect the name of additional AG Assam? Okay. And Mr. B. Goswami, learned additional advocate general Assam, assisted by Mr. J. Handik, learned state counsel for all the respondents. Full stop. Due to paucity of time, the case could not be taken up today. Full stop. As the learned counsel for the petition has expressed urgency, come at least the case. Again, it will fall below.
Then Tuesday, madam.
Saturday also, few matters to be disposed of. Oh. It will give a admission. Okay, kita. Tuesday.
Tuesday.
Kita. Okay, Tuesday.
I'm deployed.
Any interim order to be extended somewhere?
Item 39 and 40.
Interim order?
Interim order till today, Lordship.
Okay, and affidavit filed?
Affidavit not filed.
No,
I was
not
informed
filed.
that they are yet to issue
Industry?
instructions.
Tax?
Tax and industries, Lordship.
Yes. Yes, Mr. Borua, tax. Industry?
Yes, Lordship.
Kolita?
Yes, Lord.
Yes.
So not.
Not received. Tell me how much time? Heard Mr. A. Todi, learned counsel for the petitioner. Mr. H. Borua, learned counsel representing Mr. B. Gogoi, learned standing counsel, finance and taxation department for the respondent number 1, 2, and 3. And Mr. R. N.
Kolita.
N. Kolita, learned
Five.
counsel representing Mr. A. Kolita, learned standing counsel, industries department for the respondent number 4 and 5. Both Mr. Borua and Mr. Kolita, appearing for the respondents, have prayed for and are granted 3 further weeks time to file their respective counter affidavits. Release the case after a separate order. Huh? Release the case after 2 weeks. The interim order passed earlier. Interim order is there.
Yes, Lordship.
The interim order passed earlier. Shall continue till the next.
Much.
Any other interim order? Yes, MS Bora. Anything? Mr. Dole? Urgency? No. No urgency.
I have urgency, Lordship.
What urgency?
Item 50, Lordship.
Regarding,
No confidence was,
gone,
no, Lordship.
nothing survives now.
No, Lordship, municipal board, Lordship.
Huh?
Municipal
Oh,
board.
municipal,
CNFP, Lordship, Monday, Lordship.
not Monday, already posted. Lord, Saif, দিব না, huh?
My lord. Lordship, may I please, your lordship.
Persuade